The Senate Judiciary Committee will come to order. The clerk will call the roll. All in favor, vote aye if you're here. Is my mic, is it working? Can you hear me? Okay. We do have a quorum. First of all, I want to make an announcement. Senator McClellan will be replacing Senator Shervill on the Criminal Law Subcommittee, and Senator Shervill will be on the Civil Law Subcommittee. That's the change, okay? By the consent of both parties. At this time, I'd like to go, there's a couple of bills to be carried over for the year at the request of the patron. Senator Evans, Senate Bill 13 be carried over for the year. Senator Evans, Senate Bill 15 be carried over for the year at his request. Senate Bill 353, Senator Bell, I believe he asked for that to be carried over for the year. And Senator Favola. Can you hear me?
I can hear you.
Okay.
Mike's
it's on here. It's on here. Yeah, it's on here. Okay. Let me go through this again then. Senator Evans, Senate Bill 13 be carried over for the year. Senator Evans, Senate Bill 15 be carried over for the year at his request. Senator Bell's Senate Bill 353 to be carried over for the year. Senator Favola's Senate Bill 490 to be carried over for the year at her request. If I'm wrong about that, please let me know right away, but this is what I understand to be the case. All right. Now, Senator, Senator Bell?
Totally good with that. I got another one to give at the altar. SB 550, if you carry that over, it has to do a letter to the AG.
Okay, Senate Bill 550, right. And that's dating relationships, okay?
Correct. There's some issues with finding that code that I talked to the AG. They said they'll work on it over the off season. They'll absorb it, but if you could do a letter, I'd appreciate it.
Okay, thank you. We'll do that.
We need to vote.
Is there? All right. Is there a motion? Well, I guess for all of those bills I just mentioned.
Make a motion in a block to carry over all those bills, to write a letter to the attorney, with the chairman to write a letter to the Attorney General on SB 550.
Okay.
Second.
It's been moved and seconded. Those bills be carried over for the year. All in favor of the motion, vote aye. All opposed? Motion carries. Ayes 11, no 0. The motion carries. Okay, Senator Deeds will give a report of the Criminal Law Subcommittee.
Okay, the first bill, we've got Senate Bill 287 and 306. There's a substitute before you, Mr. Chair, where 287 is incorporated into 306. Senator Stanley and Deeds listed as chief co-patrons. I'd move that we incorporate them into that substitute, and I think that's a recorded vote.
Second.
All in favor of the motion to roll Senate Bill, what's the number?
It's 287 into 306.
287 and 306. All in favor, vote aye. All opposed, vote no.
Ayes 11, no 0.
Okay, this
Ayes
bill
11, no 0. The motion carries.
is a recommendation of the Virginia Criminal Justice Conference that had bow from both the Criminal Defense Bar and the Commonwealth attorneys. It allows for the entry of an order of destruction of police and court records in the absence of good cause shown to the contrary by the Commonwealth for a deferred disposition dismissal of underage alcohol possession when 1 year has passed since the date of dismissal and all court costs and fines have been paid and all orders of restitution have been satisfied, and from the possession of marijuana when 3 years have passed since the date of dismissal and all court costs and fines and orders of restitution have been satisfied. The bill also provides that any person who has received such deferred disposition dismissals may file a petition with the court that disposed of such charge for an order of destruction at any time, provided that all court costs and fines and all orders of restitution have been satisfied. The Supreme Court had some recommendations, but the subcommittee considered those, but the subcommittee recommended that the bill in substitute form be reported.
Mr. Chairman, Senator Deeds, staff believes that Senator Stanley may have had one additional amendment to make to this bill, and so we might suggest that we defer voting until Senator Stanley is here.
Okay.
All right, we'll wait on Senator Stanley. If he's in the House, please show up, Senator Stanley.
Senator,
Okay. Next bill.
Senate Bill 378, there's a substitute before you, and I'd move the substitute.
Okay. This has been moved and seconded. The substitute be adopted. All in favor, say aye.
Aye.
All opposed, no.
378 from Senator Bell expands the crime of computer trespass to provide that the prohibited actions that constitute computer trespass are criminalized if done through intentionally deceptive means and without authority, and specifies that a computer hardware or software provider, an interactive computer service, or a telecommunications or cable operator does not have to provide notice of its activities to a computer user that a reasonable computer user should expect may occur. And the recommendation of the subcommittee was to report the substitute.
Is there a second? All in favor of the motion to report we have to adopt the substitute. All in favor of the substitute, say aye.
Okay,
Aye. All opposed, no.
Okay.
All right, the motion to incorporate,
Okay, yeah, okay, I see. I'd move we incorporate Senate Bill 844 into Senate Bill 378.
is there a second? All in favor of the motion, say aye. Aye.
It's recorded.
Do we have to record? Oh, record aye. All opposed, no.
11-0.
11-0, the motion carries.
I would move that we report the bill.
Second.
Been moved and seconded that the substitute be reported. All in favor of the motion, vote aye. All opposed, no.
Ayes 13-0.
13-0, the motion carries. Okay, Senator Deeds?
Mr. Chairman,
Yeah, Senator Norman.
I appreciate that the velocity is picking up, but if I could ask Senator Deeds, was there any dissent against any of these bills that we've just reported?
There was, the dissent occurred not on any of those bills.
Okay.
We had dissent on other bills. Yes, sir. Senate Bill 438 from Senator Servell involved the judicial performance evaluation, the risk assessment tool. There was an amendment from the committee, and I don't have the amendment before me, but maybe we'd ask staff to report that.
Mr. Chair, the amendments are in the packet in front of you, but the amendment, basically what the amendment does, it takes plea agreements out of the number of cases that is reflected in the judicial performance evaluation. The amendment reads, on line 21, after offender, strike is and insert was not sentenced pursuant to a plea agreement and was. There was some discussion in the subcommittee about cases that have a plea agreement and whether or not, because plea agreements sometimes will recommend a disposition that may not be on the risk assessment, to exclude those from the purposes of this bill, because it seemed as if those cases were not having a risk assessment done pursuant to the plea agreement.
The whole idea was not to hold the plea agreement against the judge, I guess.
That's correct, Mr. Chair.
That was the purpose of the amendment.
Is there a second? All in favor?
Mr. Chairman.
Any discussion?
Senator McDougal.
Well, Senator McDougal.
Not on the amendment.
Okay. The motion is to adopt the amendment. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries.
Mr. Chair, there was a subsequent amendment brought to me by the court. It's purely technical in nature. Basically, on line 78, after evaluation, it would insert and provided to the Supreme Court by November 1 each year, so that currently the bill provides that a report needs to be delivered to the commission, but doesn't specify the period of time, and this just inserts the period of time of November 1st each year.
I have no problem with that. I move the amendment.
Second.
All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Next.
Senator McDougal has a question.
Senator McDougal.
No, well, okay. The bill requires the Virginia Sentencing Commission to report to the Supreme Court, and the amendment it gives a date certain for the report, and the chairman of the House and Senate Committees of Courts of Justice and the Judiciary, the number of cases during the judge's term in which an offender qualified for the use of a risk assessment tool received a recommendation for an alternative sanction on the basis of the assessment, and when a sentence was imposed and an alternative sanction was given. And we took out the plea agreements from that report. The bill requires the sentencing courts to use sentencing guidelines to determine the cost of incarceration for an offender who receives the minimum recommended sentence and to include the cost on the sentencing guideline form. The bill also requires the commission to determine and include on a judge's judicial performance evaluation the total cost of imposing a sentence on each offender who was evaluated by the risk assessment
Okay,
tool.
Senator Norman?
Help me understand the rationale for putting the projected costs on the imposition of the punishment.
Mr. Chairman,
It's meddling.
Mr. Chairman, can I
Yeah,
explain?
Senator North-Serval.
Thank you, Mr. Chairman. So, just so the committee has a little history, what we're talking about here is the alternate, whenever somebody's run through a sentencing guideline for a fraud, drug, or property crime, the sentencing guidelines require the probation department to do an alternative sentencing analysis to see whether or not the person would qualify for a non-incarceration type sentence. The idea behind this dates to the abolition of parole. In 1994, when we abolished parole, the General Assembly required this alternate assessment to be created to try and keep people out of jail instead of putting them in jail without parole. 2097, they started using this tool. In 2003, the Sentencing Commission reevaluated it. 2010, they made modifications where they created a bifurcated process, one for drugs and one for property and fraud crimes. Last year, there was a study that came out from George Mason, which found that judges are not following the sentencing alternative recommendation consistently, and some are refusing to follow it at all in any fashion whatsoever. And they also provided data showing that over time, fewer and fewer judges are using it. The result of that is that people are getting ordered to jail more often instead of following our evidence-based recommendation that they not go to jail. And so what the bill requires is that in any case where somebody's being sentenced and one of these applies, the probation department has to put the cost of incarceration in front of the judge along with the cost of the sentencing alternative, which is presumably less because you're not housing somebody. If the judge rejects the recommendation for the alternative sanction, for the non-jail alternative, then the judge has to make a finding as to how much the cost is, and we're going to aggregate that cost, Mr. Chairman, we're going to aggregate that cost so that we can see how much taxpayers are spending in extra money incarcerating people when probation recommends they not be incarcerated. And part of the problem that was brought to the committee's attention was that in some jurisdictions, the reason judges might be doing this is because they don't have alternative programs available in some rural localities, like they do in some of the more urban
Mr. Chairman,
localities.
I understand.
Yeah,
Thank you.
Senator Norman, okay. All right, any other questions?
Mr.
Okay.
Chairman.
Yeah, Senator McDougall.
Mr. Chairman, if the focus is on that, then I think that we ought to have the cost to the victims and the community on the same document and the cost of the law enforcement investigation as well, because if we want the judge to have all the information, then it can't just be the cost of the incarceration. It also has to be the cost to the victim and the community. So with that, Mr. Chairman, I would move that we add the cost to the victims, community, and the cost of law enforcement and any other emergency services that were required.
Any discussion on this?
Mr. Chairman, speaking to the
Senator
motion.
Serval.
Mr. Chairman, calculating the cost of how much it costs to incarcerate somebody or how much it costs to put them in an alternative program is very simple. Calculating what the cost of an investigation costs or the cost of the system is virtually impossible. And I think we would be tasking the sentencing, probation and parole with something that's impossible to conduct. And I would oppose the amendment.
Okay.
Mr. Chairman.
Senator Norman.
Just so I understand the bill before the amendment, is the calculation supposed to include any good time credit? Is the judge going to be required, or probation be required to take that into consideration, which is a variable that has no predictability?
Yeah, Senator Serval.
I would say that the senator, Mr. Chairman, that the bill asks them to determine the cost of incarceration. It'd be up to, I would think it would be up to the probation officer to, and the sentencing commission to provide guidance as to what they need to do and what process they're to follow.
Mr. Chairman?
Yeah, Senator Obenchain.
Is it the intention or that judges would be penalized if they, when they come up for reappointment, if their number, the cost number is high?
Mr. Chairman, speaking of that.
Yeah, Senator Serval.
No, it would not. The idea would be to try and find out what we need to do in some of these other localities to provide the judges with the tools they need to be able to use the sentencing alternatives. As I was starting to say before Senator Norman said he'd heard enough, was that in some localities, they don't have programs available to put people in sentencing alternatives. And if we could spend $5 million on that instead of $30 million on incarceration, I think taxpayers would be better served.
Mr. Chairman?
Okay, Senator Obenchain.
Well, if that's the reason, why put it on the performance evaluation?
Mr. Chairman?
Yeah, Senator Serval.
I would say to the senator, because that then gives us guidance as to who to ask what the problem is.
Okay. Any further discussion? We got a motion before us. Yeah.
It's just, Mr. Chairman, then,
Yeah, amendment. We have an amendment. All right.
What,
Yeah,
can I,
Senator Deeds.
Mr. Chair, where's the amendment go? What line are we talking about? Or was that an amendment in concept, or was that?
It was a better concept than the one
think
we're
it's
getting
in
ready to vote on, but
Well, we're getting ready to vote on the amendment, Senator McDougal.
than the bill itself.
Okay.
13 through what?
All right, we got a concept amendment. All right, all in favor of the concept amendment, say aye. Aye. All opposed, no. No. Okay, the amendment fails.
Mr. Chair, Mr. Chair.
Mr. Point of
Chair.
parliamentary inquiry.
All right, Mr. Chair, I think I've got
What
the
was
floor.
the vote?
I'd like to know what you're
All right, we'll go on the board then. All in favor of the amendment, vote aye. All opposed, vote no.
The amendment in concept.
It's amendment in concept only.
Ayes 6, noes 8, one abstention.
Okay, the motion fails.
Mr. Chair.
Yeah, all right, Senator Peterson.
Yeah, I'd like to make a motion, and I've been listening to the questions, and I think there's a valid concern that this would be part of a performance evaluation when there may not, the judge, they need to have their own independence. I would move that we simply just strike out that first section. It would be lines 13 through 35, which is set the portion, 12 through 35, which is the judicial performance evaluation piece, 17.1-100, and just focus on the commission itself determining these costs. So I would move. Thanks.
Okay, any further discussion? All in favor of the motion to delete which lines?
12 through 35.
12 through 35 on the bill.
Well,
Senator Deeds.
So the language you're really talking about is the italicized language on 21 through 23. You're just,
Right, but you need, just take out that whole section.
okay, take it, you're talking about, you're talking about a title amendment to take out 17.1-100 and then take out lines 12 through 35.
Right.
Take out the code section.
Just take out that whole code
Okay.
section.
All right. All in favor of the motion, say aye.
Aye.
Aye. All opposed, no. Motion carries. All right, on the bill.
Mr. Chairman,
Yeah, Senator McDougal.
that the amendment by Senator Peterson made it significantly better, but I just really have a problem if we're having the cost of the impact of the sentence on the sentencing guidelines, which is the last document the judge sees, then we should also have the cost to the victim and to the community on that same document. If we are trying to do an assessment of whether alternative sentences are being used appropriately and available appropriately, then we need to make sure that we're having all the data that's collected appropriately and not just half of the equation.
Okay,
So as Mr. Chairman, as you know, if there is a pre-sentence report, there can be some of that information in there, but there's no requirement that there would be a pre-sentence report in that guideline. So if we want to be collecting this information to make an educated decision, and it's not one that's just trying to persuade one direction, then we need to have that data collected as well.
We've already voted on that amendment, though, haven't we? I believe we have. All right.
The bill's changed.
Is there another motion?
I moved to report as amended.
Motion is made to
Mr.
report
Chair.
and seconded. Yeah, Charles?
One technical amendment since Senator Peterson's amendment's been adopted. On lines 77 to 78, the last sentence, such total cost during a judge term shall be included in the judge's judicial performance evaluation. That should be stricken.
Second.
What's that again? I'm sorry.
The last sentence.
You want to strike that?
Yes, Mr.
Yes,
Chairman.
Okay. Is there a motion?
Yes, so
Made
moved.
and
Second.
seconded. All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Okay, is there a motion on the bill?
Move to report as amended.
Motion is made to report as amended. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, nays 6.
9-6, the bill is reported as amended.
Okay, Senate Bill 440, also from Senator Servell, provides that a minor who knowingly transmits, distributes, publishes, or disseminates to another minor an electronically transmitted communication containing sexually explicit visual material of his own person or knowingly possesses at least one, but not more than 10 electronically transmitted communications containing sexually explicit visual material of another minor is guilty of a Class 2 misdemeanor, and the recommendation of the subcommittee was to report the bill.
Is that unanimous?
And I so move.
Was that unanimous?
I don't have a vote total here, but I don't recall there being any controversy.
Okay. 6-0 and one abstention.
Mr.
All right,
Chairman.
motion has been made and seconded to report the bill.
I would just
Senator
note, I
Sherman.
believe this bill is identical to legislation that Senator Stanley carried 2 years ago that the Senate sent over to the House.
Is that persuasive? That's the question? Okay, is there the
Mr.
motion been made
Chairman.
and seconded
Mr.
to
Chairman.
report the bill? Senator McDougal.
Mr. Chairman, last year, as this wound through the process, one of the concerns came, and not in the issue that Senator Servell and Senator Stanley were trying to address, but in the impact it could have with people that are bad actors. So, Mr. Benjamin, I think you walked away. I want to know what will be if you have a pedophile that's trying to get minors to produce pictures, what could be the potential impact to the prosecution of one of those individuals?
Mr. Chairman.
Senator, is there?
Servell.
Senator Servell. Okay.
Thank you, Mr. Chairman. I would just say to the gentleman a couple things. Number one is I believe that the transmission and dissemination has to be between minors, so it has to be minor to minor in order for it to qualify for the misdemeanor offense. And then secondly, I would note that on line 17, we put in language that said that this only applies to less than 10 images. So if there's more than 10 images that are created, then it gets into felony territory.
Mr. Chairman?
Okay, Senator McDougal.
So what if one minor asks another minor for pictures, and they send them 5, and then somebody that we think is really bad, that's not a minor, takes those 5 pictures, and then they disseminate them? How is that individual going to be treated because they didn't produce it? It was not a felony when it was produced. Isn't that going to hinder our ability to prosecute
Mr. Chairman?
those individuals?
Yeah, Senator Servell.
I would say to the gentleman that no, because I believe the possession of an adult of a picture of a minor is a felony, and I think counsel can confirm that for me.
Okay. Any other questions?
You're making a
All right, it's
mistake
been
here. I
moved
think you got a problem.
and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 13, no 0.
That's 13-0, the
Okay.
motion carries.
If we can go back to 306, I think we've already incorporated 287, and I think Steve has an amendment that he and Senator Stanley have worked through.
That's correct, Mr. Chairman. On line 214 to 215, that's on page 9 of the substitute, strike the language for a violation of section 18.2-250.1. On line 221, strike the same language.
Okay. Is there a second?
Second.
Yeah, all in favor of the line amendments, vote aye, say aye. Aye. All opposed, no.
And with that line amendment, the bill's exactly what it was when I described it about 10 minutes ago, and I would just move to report.
Okay, it's, motion has been made and seconded to report the substitute. Does this have to go to finance? And re-refer to finance?
Yeah.
All in favor of the motion, vote aye. All opposed, vote no.
Hit Norman's. Hit Norman's.
Ayes 13-0.
Ayes 13-0, the motion carries.
Okay, then we go to Senate Bill 775. That was your bill, Senator.
Yeah.
Mr. Chairman, you asked that the bill be stricken from the docket. And I'd so move, 775.
And seconded, all in favor of the motion to strike Senate Bill 775 dealing with discovery in criminal matters. All in favor of the motion to strike, vote aye. All opposed, no. Vote no.
Get it.
Ayes 14-0.
14-0, the bill is stricken.
Okay, Senate Bill 793 is Senator McClellan's bill. It's one we're familiar with. And we know as a fishback exception for no parole, it would allow parole eligibility to those defendants who were incarcerated if such person was sentenced by jury prior to the date of Fishback v. Commonwealth in June 9, 2000, which the court held that a jury should be instructed on the fact that parole has been abolished for a non-capital felony committed on or after the abolition of parole went into effect January 1, 1995, and the jury was not instructed on the abolition of parole. We had a substitute for that bill, and the substitutes before you, I'd move the substitute first.
The incorporation of Senator Morse's bill, Senate Bill 821.
Okay, yes.
It's been moved to incorporate that bill. All in
793 or 821?
It's incorporate Senate Bill 821 into Senate Bill 793, the fishback issue.
That's right.
All in favor of the motion to incorporate, vote aye. All opposed, no. Motion carries. Well,
Ayes 15-0.
And then we reported,
motion carries 15-0.
we recommended that the substitute be reported
And refer to finance.
and referred to finance.
All in
Yes.
favor of the motion to report the substitute and re-refer to finance, vote aye. All opposed, vote no.
You're against this one? You're against this one? It's good
Okay.
for it to, the fish.
Ayes 13-1.
13-1, the motion carries.
Okay, the next was Senate Bill 803, which was Senator Morrissey's bill, and we recommended that bill be carried over till next year. And I'd so move.
All in favor of the motion to carry over Senator Morrissey's Senate Bill 803, vote aye.
Mr. Chairman,
All opposed, vote no.
I just had a quick question.
Destroy the roll, Mr.
All right,
Chair.
strike
I had a
through
quick
the
question. I wasn't there for the discussion of that bill on subcommittee, but are we asking the compensation board to look into the issues raised by the bill?
Senator Morrissey.
Senator Servo, we are. I also gave prepared a draft letter
Okay.
for the subcommittee
That's right.
chairman to give to the chairman, and you should have that.
Okay, that's all I wanted to know.
So that motion would be rather to strike, to continue the bill to 2021, have the chairman write a letter to the compensation board.
Okay. All right, with that, motions before you.
Excuse me, just for clarification, the letter was to Jeff Hasel at the Virginia Association of Commonwealth's Attorney. They have started and implemented a VACA staffing standard committee, and the letter will request that they send a letter to the chairman and to me by next year.
Okay.
Okay, all right. The motion's before you to continue, you carry it over for the year with a letter. All in favor of the motion, vote aye. All opposed, no.
Am I signing? Am I giving you money?
15-0.
It's 15-0, the motion carries.
Okay, Senate Bill 805 did have some controversy, but in the end, we recommended reporting, and it was a split vote. I don't have the vote in front of me.
4-3.
4-3. I think we had a substitute, and that's before you. I'd move the substitute.
There's a second. All in favor of the motion to adopt the substitute, say aye. Aye. All opposed, no. The motion
No.
carries.
Okay, Senate Bill 805 defines robbery and creates, creates different grades of the crime of robbery.
Gradations on robbery.
Yeah, creates degrees of punishment corresponding to the severity or perceived severity of the offense. Any person who commits a robbery by causing serious bodily injury is guilty of robbery in the first degree, which is punishable with a maximum term of life. Any person who commits robbery by displaying a firearm in a threatening manner is guilty of robbery in the second degree, punishable by confinement in a state penitentiary for a maximum term of 20 years. Any person who commits robbery by using physical force not resulting in serious bodily injury or by displaying a deadly weapon other than a firearm in a threatening manner is guilty of robbery in the third degree. That's punishable as a Class 5 felony. Any person who commits robbery by using threat or intimidation not involving a deadly weapon is guilty of robbery in the fourth degree, punishable as a Class 6 felony. As you know, under current law, all robbery is punishable by confinement of 5 years to life. So we adopted a substitute, which we've already adopted, and the recommendation of the subcommittee by 4-3 vote was to report.
Okay, Senator Norman.
Mr. Chairman, I would ask Senator Deeds, because we're proposing to create various gradations of robbery, is this in fact infringing on the discretion of the judge to make certain determinations?
Well, Mr. Chair, I would say to Senator Norman that I guess it's no more infringing on the discretion of the judge than any other defined offense. You know, you've got first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter. I guess anytime you have gradations of offenses, you are removing some discretion, but the General Assembly decides the policy of this Commonwealth.
Okay, Senator Morrissey.
Thank you.
Mr. Chair, I'd also say to Senator Norman that what we're doing here is nothing unique. Take malicious wounding. We have gradations right now from simple assault to unlawful wounding to malicious wounding to aggravated malicious wounding. With regard to Senator Norman's specific question about removing the discretion of the judge, if it was a judge trial, the judge is going to be determining which gradation of robbery it is and sentence accordingly. Similarly, if it's a jury trial, Senator Norman, the jury would have perhaps 3 or 4 of those alternatives to decide which to find the defendant guilty of.
Okay. Any further discussion? Yes, Senator McDougal.
Mr. Chairman, just want to, I had this conversation, but want to make sure everybody's aware. So right now, if there's serious bodily injury, which is a break of the skin or could be a broken bone, something of serious internal nature, you'll be in the highest penalty. But if you display a firearm, you shoot into the ceiling or shoot into the floor and don't hit anybody, the penalty will be no greater than grand larceny now. But Mr. Chairman, if you shoot that same firearm into the ceiling and a fleck of ceiling tile breaks off and cuts somebody, even superficially, you could go under Section 1. Mr. Chairman, I understand what the effort is, but I cannot support and don't think this committee should taking the use of a firearm in a robbery and having that penalty not be in the highest category.
Mr. Chairman.
Senator Morrissey.
A couple of points. The committee should not forget that along with this underlying offense of robbery, the jury would also be able to consider use of a firearm in the commission of a felony as an additional offense. Second of all, with regard to the specific comment that Senator McDougal said, the historical context of punishing individuals who commit an injury with a firearm is within this range. So again, nothing unique or novel other than something that makes, I think, that is practical, and I'd ask that the committee pass the bill.
All right, any further discussion? All right, is there a motion? Do we have the motion? It's been moved and seconded that the bill, the substitute
Mr.
be
Chairman.
reported. Senator McDougal?
Mr. Chairman, and I thought I had paid fairly decent attention to this. I did not think we heard any specific testimony from the Sentencing Commission about use of a firearm in a robbery and where those penalties lay. I thought we heard generically robbery, which would include all these, and I understand what the senator's trying to do, particularly in Part 4, but that Part 2 is really concerning, and if that is the case, I'd like to have Meredith come tell us what specifically use of a firearm in robbery, and my guess is she doesn't have, even if she has that, she doesn't have threatening manner, but use of a firearm would be helpful.
Mr. Chairman, members of the committee, I'm Meredith Farrar Owens, I'm the Director of the Criminal Sentencing Commission. In regards to robbery with the firearm, in most of those cases, the vast majority of the cases, we see that the king in charge of use of the firearm in the commission of a felony, which, as you know, requires a 3-year mandatory sentence for the first offense and a 5-year mandatory sentence for the individual second or subsequent offense. Based on the under sentencing guidelines, any mandatory minimum is going to trump whatever the sentencing guidelines recommendation is if that mandatory exceeds what the guidelines would recommend in the case. So the mandatory is going to take precedence over the guidelines.
Mr. Chairman?
So what-
Senator Morrissey.
Meredith, I also received the impact of the proposed legislation, and I shared this with the subcommittee, and I think this is the question that Senator McDougal was focused on. I said at this subcommittee meeting that the median prison sentences in recent robbery cases are within this reduced statutory maximums that have been proposed. Is that correct?
We do have that information in that statement, and you are correct, Senator Morrissey. What we report, though, is the median prison sentence in each of those situations. So that means half of the sentences are below that value, and half the sentences are above that value. So there could be some, I don't have the number here, but there could be some that would exceed, for example, the 20-year maximum that you would specify where there's use of a firearm but not a serious injury. The median prison sentence in those cases is 8 years, but there may be some cases that are beyond the 20-year. We could analyze that. I just don't have that data with
One
me.
final question, Mr. Chair.
Senator Morrissey.
So in the scenario that I suggested earlier, to give guidance to this committee, if a firearm were used in a robbery, they would face an exposure not only of the 20-year sentence, but an additional mandatory minimum sentence for use of a firearm in the commission of a felony. Is that correct?
Mr. Chairman, very likely.
Not likely, it's mandatory minimum. If they were found guilty,
Yes.
it's not likely, it's a mandatory minimum sentence.
Yes, if very likely they would be charged with it and then if they found guilty.
Senator Sasslaw.
Well, if the sentence for the robbery, and I was the one I think in '84 that put that on the books, which you're currently referring to, the minimum mandatory for 3 years, the first time with a gun, 5 with the second. It seems to me that if the sentence was 10 years, it would have satisfied the mandatory minimum. Mandatory minimum wouldn't be in addition there too. They've already pulled that.
Mr. Chairman, perhaps staff can assist with this. I believe the language in the use of a firearm in the commission of a felony statute requires that sentence to be in addition to and consecutive to the sentence for the predicate offense, in this case, the robbery.
Mr. Chair?
Senator Morrissey.
Senator Sasslaw, that's exactly correct. In addition to the sentence for robbery, there would be a required mandatory minimum sentence of 3 years on top of that, so it would be 13 years. If there was another felony that was used in that same course of action, then there's a second mandatory minimum of 5 years for that firearm.
Question.
Yes, Senator Sasslaw.
Somebody goes into a 7-Eleven, pulls out a gun, says, "Give me your money," to the cashier. Cashier gives them, say, $1,000, which is felony range. What's the average sentence on something like that? How is that usually handled?
Mr. Chairman, in the Sentencing Commission's impact statement, when we did the analysis of looking at robbery where there was an additional offense of use of a firearm, we found that 99.5% of those individuals were in fact given a state prison sentence, and the median prison sentence in those cases was 8 years.
With the current law?
With the current law, with no injury.
With no injury. So his no injury is what? On the bill that he's proposing? You
Yes.
pull a gun, you go into the same 7-Eleven, no injury. What would Senator Morrissey's bill do?
20.
Yes, the statutory maximum would become 20 years, Mr.
So they
Chair.
get more than they currently are getting,
Up to that max.
up to.
Mr. Chairman,
Yeah, Senator McDougal.
I don't think that's accurate, because it's two different ways. If you look in Part 2, it's display a firearm in a threatening manner. You could even discharge that firearm. And in Section 3, it's any other weapon or a firearm in a non-threatening manner. My concern about Section 2 is that the firearm in a threatening manner could be discharged, it could be used in some way, and the max is now 20. And if it's just in the person's pocket and they oftentimes intimate that they have something, even if they did not, I understand where the attempt is. But if you're displaying a firearm in a threatening manner, regardless of whether that harm is achieved or not, again, the example I give you, they can pull it out, they can shoot 10 rounds into the ceiling, and the maximum penalty is going to be the 20 plus 3. And so, Mr. Chairman, that's the part that I cannot support.
Mr. Chairman.
And have a concern about.
Mr. Chairman.
Yeah, Senator Morrissey.
I hope this is the last response to it, but I want to address Senator Saslaw's inquiry. He asked a question the senator asked a question, if you displayed a firearm and you go into the store, you don't shoot it, but you show that firearm, that person faces a maximum of 20 years under my guidelines, which is 12 more than the medium given, plus 3 years mandatory minimum for a potential sentence of 23 years. As Meredith stated, the sentencing guidelines right now, the medium range for a crime like that is 8 years.
Okay. All right. Any further discussion? Is there a motion? It's been moved and seconded to report the substitute. All in favor of the motion, vote aye. All opposed, no.
Louise?
Ayes 10, noes 5.
As 10, those 5, the motion carries.
Okay, Mr. Chair, we just have a few more bills. Senate Bill 840 from Senator Eben. I think there's a substitute before you, and the substitute makes some technical changes to the language. I think, so I'd move the substitute.
Okay. Is the substitutes before you? All in favor of the substitute, say aye. Aye. All opposed, no.
Okay, this bill simply makes various changes to the provisions regarding confinement hearings and conditional release procedures for a person who's been acquitted of a violent felony by reason of insanity. Under current law, such provisions don't distinguish between persons convicted of a violent felony or any other felony offense. With that recommendation, or with that explanation, I'd move that we report the bill.
Okay, it's been moved and seconded that the substitute be reported. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 15, noes 0.
Ayes 15, no zero, the motion carries.
Okay, Senate Bill 1017 from Senator Stanley was the bill he had last year that involved basically junk science. We moved to pass that bill by indefinitely, but write a letter to the Crime Commission to ask them to take a look at the subject matter of the bill. And I'd so move.
All in favor of the motion to pass by indefinitely with a letter, Senator Stanley's Senate Bill 1017. All in favor, vote aye. All opposed, vote no.
Okay.
Motion carries.
Okay, the last.
15 to, wait a minute.
15-0.
15 to 0, the motion carries.
The last bills had to do with parole, and the subcommittee made no recommendation on those bills. The first thing I'd do is move that we incorporate Senate Bill 805 from Senator Morrissey into Senate Bill 91, Mr. Chairman, your bill. And I'd move the bills being, the 805 be incorporated into 91.
All in favor of the motion, vote aye. All in favor of the motion to, let's see, where are we?
To incorporate 805 into 91.
Is there a second?
And list both as chief co-patrons. 805.
One was 10-5.
It's 809, I'm sorry.
809 into Senate Bill 91.
Yes.
All in favor of that motion, vote aye. All opposed, no.
That's incorporated.
Yeah, incorporation.
Just for incorporation. Now, as with,
That's 15-0.
I'm going to turn it over to Senator Deeds, and I'll present the bill.
with that incorporated, Mr. Chair, the bill repeals the abolition of parole. The bill provides that the parole board shall establish procedures for consideration of parole for persons who previously were ineligible because parole was abolished, but we had the tie vote in the subcommittee, so.
All right, I would like to move, there's a substitute, and the substitute basically exempts violent crime from the repeal of parole.
Okay.
Repeal of no parole. That's basically what it does.
Mr. Senator Sassol.
Got your definition of a violent crime, murder, rape, armed robbery, et
Well, you
cetera.
look, Senator Sassol, Mr. Chair, look down on line 19. Violent crime is defined statutorily in 17.1805. It's on line 17 on line 19.
What is that?
Well, it involves the offenses you were talking about, but I think it's more expansive than that.
Yeah, council can you explain what the violent criminal crimes are that are exempt from this bill.
Yes, let me pull it up, though.
Okay.
17.1-805. This is violent crime.
Section 17.1-805, is that right?
Got it. Mr. Chairman, 17.1-805 lists and defines what constitutes a violent crime. You don't want me to read this list. We'll be here the rest of the morning. It goes on and on and on. Suffice to say, it covers every violent crime in the Code of Virginia.
It includes murder, rape, and robbery.
It includes everything.
Murder, rape, robbery, et cetera.
It's all there.
Anything that's violent.
Anything.
But it also includes a lot of drug offenses, is that correct?
It's hard to hear here, so can you make sure?
It includes a number of drug offenses, is that correct?
I don't believe that it does.
Okay.
It's hard to tell because it's all by code section.
Okay.
But I don't see the drug offenses.
Okay. I move the substitute. Is there a second?
There's a motion and a second that we adopt the substitute which exempts violent crime from this bill. All in favor of adoption of substitute, say aye.
Aye.
Opposed, no. Okay, Senator Norman's got a question.
Yeah, Senator Norman.
I'll wait till the motion. Okay.
May I ask a question?
Senator Peterson.
I wasn't on this subcommittee, but let me ask a couple questions. So is this studying parole, like bringing back parole, or is this just basically bringing back parole for all nonviolent crimes?
That brings back parole for nonviolent crimes.
Okay, further question.
Yeah.
Senator Peterson.
Are we going to set any guidelines, like you have to do 50% of the sentence or 30%, or? Because before it was typically you do 30% of the sentence.
It's in the code about how to do that with guidelines.
And the evidence before the subcommittee was you did about a 25% of the sentence for first-time offenders, I think.
Okay,
And then a third for second time and so forth. It's already in the code.
further question.
Senator Peterson.
We've had bills about the jury being instructed that there was no parole for certain. Are they now going to be instructed that there is parole?
That's not in the bill. That would, something that could be taken up later. That's not in the bill. That issue is not in the bill.
Well, hold on a second. Further question. So a jury could be argued and think that they're given a 10-year sentence for embezzlement of an elderly couple or some type of thing, and it turns out it's really a 3-year sentence.
Well,
Mr. Chair.
Yeah, Senator Morse, go ahead.
Mr. Chair, could I address that inquiry?
Senator Morsi.
I would tell Senator Peterson that prior to the abolition of parole in 1995, juries were prohibited from being told that the person was eligible for parole. It was only after the Fishback decision that jurors were told that there was no parole. So it doesn't go both ways. Under this bill, there's no language in it that where a jury would now be told that parole has been reestablished in the Commonwealth of Virginia. It is simply something that would not be for their consideration.
Mr. Chairman,
Yes.
Senator Obenshain.
does that mean that we presume that jurors don't read the newspaper? That they're not going to know what we've done? That they're not going to be confused about which offenses are subject to parole and which ones aren't? That they're going to haphazardly impose sentences that based upon erroneous assumptions about parole?
Ms. Senator Obenshain, you're making an argument, not asking questions, I guess.
Ain't that right?
Can I,
Senator Morsi.
in a case of a violent felony, the jury would be told that there's no parole in Virginia. That's the instruction that they would be given.
Mr. Chairman?
Senator Obenshain.
So we just assume that they think that there's no parole for property crimes, nonviolent crimes? And is that a good thing?
Mr. Chairman, I think one possible answer to the question is that Virginia is, it may be the only state in the country, there may be one other, that uses juries for sentencing, creating essentially a double standard. Judges have information that juries don't. Judges have powers like to suspend sentences that juries don't. But it's always been the policy of the Commonwealth to maintain jury sentencing, which means that we have problems such as this. The real answer to the problem would be to mandate that only judges perform the sentencing function. But so long, Mr. Chairman, as we maintain jury sentencing, there will be complexities such as Senator Obenshain mentions. We just do, this committee does the best that it can.
Mr. Chairman,
Senator
in
Edwards.
speaking to the bill, America is a nation of second chances. If you have the opportunity for parole, it's an incentive to act properly, and then you'll get out on parole under conditions, and if you misbehave, you violate the terms and conditions of parole, you go back. It worked. Since 1990, there's been an increase. We've doubled the size of our prisons since 1990 to 2018, the last figure. And we're incarcerating more people of color on a ratio of 2 to 1 per capita. 2 to 1. In addition to that, from 1990 to 2018, the number of geriatric inmates has gone by nearly tenfold, from 882 to 8,000. These are geriatric patients defined as, typically over 55 years of age. In fact, the fully 41% of Virginia's prisoners are 55 years of age or older in 2011, much higher than the 25%, which is a national average. In addition to that, the healthcare costs have gone up 40% over the last 5 years. From 2014 to 2019, $223 million in healthcare costs because of this.
Mr. Chairman.
Mr. Chairman.
Senator Sasslaw has a question. Senator Edwards.
I was going to wonder if, when that bill got put into effect, it was 93 or 94 to take effect in 95. At the time, our recidivism rate was 67.6%. Okay? Last year, or 2 years ago, it was down to 23% and was the lowest recidivism rate in America. It hasn't had a totally negative impact by any stretch. You do understand that.
No, there's no, the correlation isn't accurate. When people are over 50, they typically don't commit as
Well, no,
many crimes. They age out.
And I have no problem with
No,
geriatric
many of
type
them do.
parole, but it has made a tremendous impact. When you drop your recidivism rate and we were about at the national average, John, and now we're down in the low 20s and we're the lowest in America. So it's, you can't totally ignore that.
Well, it's not necessarily a correlation.
Senator Norman.
Senator Norman.
Mr. Chairman, I'm going to make a motion to carry it over, and if I may speak to that motion, please.
I'm not finished my eloquent hour-long presentation, okay?
Well, Mr. Chairman, I've learned eloquence is a subjective evaluation.
I'm sure it is. In this country, we have 25% of the people in the world are locked up, incarcerated in America, and yet we only have 4.4% of the world's population. Give you some figures. We have in this country, in Virginia, 779 people out of 100,000 are locked up. Compare that to the European Union countries, the original European Union countries, 102.5 persons per 100,000. We're at 779. Canada, 114,000. We're at 779. The rest of the country is about 668,000 out of 100,000. The point is, and China is 164,000 per 100,000. Russia, 364 per 100,000. We're 779. We're locking them up more than anybody else in the world. And there's an alternative. Parole gives people an incentive. It gives them hope. It gives them an opportunity to do better, to improve themselves. And if they get out and they violate the terms and conditions, they go right back. And it works. And so I would ask that the bill be, I think Senator Morsi had an idea, too, that came up in committee.
Senator Morsi.
Just a couple of points. There are over 38,000 people that are currently incarcerated in prisons in Virginia right now.
38,000.
And under the new law that went into effect in 1995, that abolished parole, prisoners are no longer able to earn good time allowance as the rate that they could earn prior to 1995. And that ties in with Senator Edwards' comment about incentivizing people. If you want to incentivize prisoners to take advantage of the plethora of opportunities that are with them in DOC, then you have to reestablish parole. And remember, all this means is that they are eligible to come before a body and be considered for parole. It does not mean that they are getting parole. And when they come before that body, the parole board, they're looking at their institutional record, which may show 15, 18, 20 years of stellar behavior. And in that situation, it gives the parole board the opportunity to say, they have a 38-year sentence, but for the last 22 years, they've led a stellar life in prison. They've taken advantage of every program available to them. We're going to take a chance that this person is salvageable, that this person has redeemed himself or herself. And oh, by the way, we're going to save the Commonwealth $22,000 a year. So with that said, when it's appropriate, Mr. Chairman, I'll have a motion.
Yeah, it costs over about $43,000 a year.
With capital costs.
Capital costs to lock somebody up.
I think Senator Norman made a motion. Is there a second
Could
to
I
that
ask a
motion?
question?
Senator Obenshain.
In light of the statistics about
You have a
costs,
okay, Senator Obenshain.
I'm kind of curious as to whether you have at your fingertips the cost incurred as a result of recidivist crimes committed by people when they're out. I mean, how much do those cost, to Senator Saslaw's point about the dramatic decrease in recidivism? So if we're going to talk about the cost of incarceration, I think it's only fair to talk about the cost of prosecuting and the cost to the community and the victims of the increase that is inevitable in crimes as a result of this.
Mr. Chairman?
Yes, sir.
Senator Morrissey.
While I don't have it at my fingertips, during the subcommittee meeting, we did hear testimony regarding recidivism rates. Maybe that person is still here, but I would acknowledge to Senator Obenshain that that would be a consideration, those individuals that get out. But I'll say this. What is interesting to note, and I pointed out to the subcommittee, even though we are excluding the most violent crimes from here, the statistics show with overwhelming empirical evidence that people that are convicted of first-degree murder, of all the categories of crime, are least likely to become recidivists. Anyway, that's not a factor here because we're excluding violent crimes from this.
And Mr. Chairman,
So we have a motion to carry over.
Next year, Mr.
We have a-
Senator Saslaw.
We have a motion to carry over that's been seconded.
I
Is
moved
there
it, substitute motion.
Substitute
To
motion.
report the substitute. And send to finance, it's got to go to finance.
Mr. Chair.
Report and refer to finance.
Mr. Chair.
Senator Norman and then Senator Servell. Peterson.
Peterson.
Mr. Chairman, I would ask that we not report the bill, and on a later date, on a different subject, I'm going to have the same theme. One of the things, Mr. Chairman, that I've noticed is that sometimes all of us tend to think in silos, and I don't mean that as a criticism. We have multiple committees going on at multiple times, and all of us don't serve on those committees. For instance, a bill has been reported out of the Rules Committee to study the abolition of parole, but not everybody sits on Rules Committee. So here, we're going to take an action to, in essence, abolish parole, even though another committee has made a determination that it is a significant policy shift that ought to be looked at carefully to make sure that we understand the implications of it. And here are some of the implications that have been brought up. How are we going to handle the jury trials? Or is it a hypocrisy on the jury trials to say we're going to advise a jury that there's no abolition of parole on violent offenses, but on nonviolence, we are not going to advise them that parole has been abolished in Virginia. Another very significant concern, at the same time we are addressing this, there's legislation moving that grants geriatric parole that's going to be reduced from 55 to 50. That is going to have an impact. Finally, I would say that the parole board is appointed by the governor of Virginia, and various governors have differing perspectives on how they would like for that parole board to act. I don't say it with any criticism, but it would be my anticipation that the next parole board is going to have a more charitable or lenient approach to it than perhaps they did under Governor Allen. And once again, I offer that only by comparison purposes, not for criticism. And so, Mr. Chairman, I think carrying this over would give the opportunity to undertake the study to really understand the implications of what we're doing as opposed to advancing this at this time.
Okay, Senator Morrissey was next, I think. Senator Peterson, I apologize.
Yeah, just to follow on, I think, first of all, this is a critical issue, and we've already passed bills just in the last hour about getting rid of mandatory minimums, which I support. We've passed bills to basically right-size our sentencing regime to make sure there's proportionality, which I support. What we're doing here would be just basically wholesale changing the sentencing regime for certain classes of crime. And by the way, the definition of violent versus nonviolent crime is extremely arbitrary. So some people are still going to get caught up in the whole old system. I want to note a couple things. One is, and I'm younger than some of the folks here, but I remember very well the old regime. We had parole in this state for years, and we consciously went away from it. And after we did, there was a significant drop in our crime rates. Now, I'm not saying they're correlated, but there was. And we've had significantly lower crime for the last 25 years than we did before 1993. Now, you can say that's irrelevant. Maybe it is, maybe it isn't. But that's something that has to be noted. Second thing, well, I heard that comment, but I'm not gonna repeat it. The second thing is, there's a significant issue that we do have jury trials in which, and if you're gonna try a case, and I know I've got some of the top trial attorneys to the left and right of me, you're gonna ask for a jury, because you can win a jury case where you can't win a bench case. But then you're locked in, if you lose, to a jury sentencing. And we're gonna put juries in a position where, in some cases, they're gonna be instructed there's no parole. In some cases, they're gonna be under the impression that there is parole. It's gonna be wildly confusing. And we don't have any of the safeguards in place right now to sort of adopt this rule. So I realize this is, a partisan issue and people are gonna break down how they break down, but this is the type of issue where we need to put the brakes on and have a regime in place that makes sense across the board. And I don't think we're there right now, so.
Mr. Chairman?
I would like to wait a year, at least a year on this issue.
Senator
to get some
Edwards.
better information.
If you're not eligible for parole until to serve 85% of your time, the parole board can't deal with it. What happens is, the governor's office gets tons of requests for conditional pardons, which is to go below the 85%. Only the governor can do that. And the governor's overwhelmed with these kind of applications, and it's not set up to do it. It ought to be in the parole board.
Wasn't the evidence at the subcommittee that from the parole board and the sentencing, or from the parole board, I guess, that the people who are really affected by no parole are violent offenders? They're the ones that are serving longer time, and nonviolent offenders are serving about the same amount of time they got before.
Yes.
It depends. It depends. But they have to serve 85% of the time before they're even eligible. And we do have in guidelines what the parole board can do. It's already there.
Mr. Chairman, speaking to one of the motions. So I agree 100% with what the chairman is trying to do. I have concerns about the amendment we made a minute ago, because I think the amendment takes the bill backwards in a bad way. I think some of the biggest travesties of justice we've had are on some of these violent crimes, or so-called violent crimes, or crimes that have been classified as violent by the code, I would say. For example, I wrote an op-ed this summer about a kid named Edward Sims, who was my age. And when he was 16 years old, 1987, he got sentenced to 60, 70, 80 years in jail for 3 robberies that occurred over a period of a week where not a single person got hurt. He didn't get out of jail until 39 years later, when the parole board granted him parole, because they recently reinterpreted exactly what authority they have for robbery crimes. Well, the amendment that was made a minute ago carved violent crimes out of the reinstatement of parole. And those are some of the worst ones. And so by trying to do this on the fly like this really quick, I think we might be missing some of the more important pieces. And so, this is a really complicated problem. And I just think we need to take a long period of time with a lot of people looking at it and chewing on it for a year before we go and start
Mr. Chairman,
making policy changes.
it's got to go to finance, and it's a working process.
Mr. Chairman. Addressing Senator Edwards' last comment, having the privilege of co-chaired finance and staying on it, and what is in that finance committee right now, at some point, we have got to stop sending every bill to finance to make the ultimate policy decision, because we are not going to get through this session. We are not going to make it through in a timely manner. But more importantly, Mr. Chairman, I am fully aware that there are partisan issues that are before us this year, especially following a rather contentious election cycle. And I understand that and respect that. I don't consider this a partisan issue. I don't consider this a Republican or a Democratic issue. This is a very, very serious policy decision that has enormous implications, regardless of where we may fall on it. And you just heard from Senator Surville issues that he has. And they're totally different than the issues that I have. And I just think it would be precipitous for us to pass this bill out of committee in the current form.
Senator Edwards?
Yeah.
You want to close it out?
Yeah. Mr. Chairman, no parole has not worked. We have twice as many, 41% are geriatric patients. We have twice as many people locked up as before. This is a nation of second chances. it gives hope and incentive for those who are in prison to have an opportunity for parole. Right now, they don't have an opportunity. And if they're out on parole, they violate, they can come back. No, it's not a perfect bill, but it needs to be continued in the process, going to finance and work
Yeah,
on.
I think we understand. The motion is to carry over. All in favor, vote aye.
No, I had a substitute motion.
Substitute motion, I apologize.
Substitute motion.
Substitute motion is to report the bill. All in favor, vote aye.
Can you vote for me?
You can vote up there.
Yeah, okay.
What's this? What are we voting on?
Ayes 5, noes 10.
Senator Norman.
Primary
I would
motion?
make a motion to carry the bill over.
Well, that was the primary motion, so we're going back to that right now, that your primary motion was to carry
Yes, sir.
over. So,
Mr. Chair,
Senator McClellan.
before we vote on that, I have one question. Back in, I think it was 2015, Governor McAuliffe issued an executive order putting a commission in place to study parole reinstatement. Did they ever issue a report?
You know,
They never
I
did.
don't know that they did. I know we had in rules just on Friday, a resolution called for the study of parole. I don't recall what happened to that resolution. I think we may have passed it, but I don't remember.
It did pass.
Okay.
So if we're going to carry,
It went to the crime commission. It went to the crime commission.
okay,
I believe it went to the crime commission.
No, but we passed the resolution.
Okay, thank you.
okay.
Yeah.
All in favor of carrying the bill over for the year, vote aye. Oh, no, I'm sorry. Okay.
Thank
Ayes
you.
15, no 0.
Okay, the bill's carried over. So that was the conclusion of our report, Mr. Chairman.
If they're studying it, let them study all that.
It needs to be continued, though. Anyway.
They're studying it.
Then, let's see. All right, we have some members of the Senate who are here. Okay, Senator Cosgrove is first.
Well, good morning, Mr. Chairman, members of the committee. I have Senate Bill 359. Mr. Chairman, Senate Bill 359, give you a little background about this. A friend of mine bought a house in Virginia Beach for a substantial amount of money. Closed on July 25th. The first week in August, he was notified by his title company that he did not own the property. The reason was that somebody had gone to the clerk in Virginia Beach and filed a fraudulent deed of gift. Now, in talking to the clerk, if somebody brings a deed of gift that is properly notarized, et cetera, she has no choice but then to register that title, record that title. So I put a bill in that would require that any deed of gift have a title search done to it, but that's, in talking with the people involved, that seems to be a little too much.
Do you have a substitute?
Mr. Chairman, I actually have an amendment. I talked to staff about it. All I want to do is just require that when a person brings a deed of gift to the clerk, they must also present a certified copy of the existing deed. So if the existing deed says John and Sue Cosgrove own this property, but on the deed of gift, it says that Joe Smith is deeding this as a gift to somebody else, the clerk then sees, hey, there's a problem here. Now, my friend had to spend almost $10,000 going to court and having the circuit court instruct the clerk to not record that deed. And it happened to 8 different people in a 1-mile radius in that one neighborhood. This is a problem in Hampton Roads. This is a problem in Northern Virginia. I believe it's a problem in Richmond. This would just make it a lot more difficult to make that happen. And if staff could provide that alignment we talked about, I'd appreciate it.
Mr. Chairman, it would be a substituting concept that would basically say, no clerk shall record a deed of gift conveying real estate unless such deed is accompanied by a certified copy of the existing deed showing the current owner of the real estate subject to the deed of gift.
Okay, any questions? Is
Mr.
there
Chairman, I
a
have a
motion? Yeah, Senator Searle.
So How is the clerk supposed to be able to confirm that the certified copy of the so-called existing deed is actually a certified copy of the existing deed?
Mr. Chairman, the existing deed would be at the clerk's office. I mean, that's a document that comes from their office.
Mr. Chairman?
Senator Sherrill.
Yeah, but I know it's in the office, but the only way to determine if that's the existing deed is to do a title bring down.
Mr. Chairman, again, I don't want to subject this to a title search because, again, in the end of the year with tax time, people doing deeds of gift of real estate, apparently there's quite a few that come before the clerk's offices. This would be a pretty heavy requirement on that, on legitimate deeds of gift. All this does is it just shows that basically, and I understand what you're saying, but at the same time, right now, there's nothing. There's nothing. In this case, my friend had this property. Somebody came in and basically said, it's a deed of gift from a one Jackie Jones to another gentleman. They had no title, they had no claim to the property, had never owned the property. They just found 8 separate properties and filed these deeds of gift. Now, when we went to the Detective Bureau in Virginia Beach, they basically went and notified all these people, but they would have had no idea that their property had been encumbered. And what happens is when you have that deed of gift and it's recorded, that fraudulent person then can take out loans on the property, use the equity lines on the property, et cetera. It's just way too easy to do a fraudulent transaction.
Senator, I've seen that happen. I think you're absolutely right.
So, Mr.
Senator
Chair,
Deeds.
what happens, the clerk then has the responsibility to determine of looking at the certified deed and determining that was the last deed in the chain of title.
Yeah, Mr. Chairman, I say yes. The clerk would look at that, and that would give them indication there's something wrong with this transfer.
Mr. Chair,
Senator Deeds.
if the clerk makes a mistake, that sets up liability on the clerk's part.
Well, potentially.
Mr. Chairman, again, I'm not a lawyer, but we have to do something to protect
clerk
these
can
property
receive
owners.
them out,
It's
right.
much too easy the way it is right now, just to fraudulently steal the title to a piece of
Chairman.
property.
Mr. Chairman.
Senator Stewart.
Mr. Chairman, thank you. Senator Cosgrove, what you're suggesting is akin to having a clerk decide whether a lawsuit has merit or not when an attorney files it. And that's the province of somebody else. It just, don't you think that puts an unrealistic burden on the clerks of court to ask them to do this?
Mr. Chairman, I would actually say no to that because the clerks right now, if something looks out of sorts, out of place, they can actually question that title now. This just gives them one more piece of evidence that it is viable or not viable.
And Mr. Chairman, Senator, as I understand it, the substitute would simply say the clerk, whoever files a deed of gift has to provide a certified copy of the exact title of the property. That's
Yes,
all.
sir. Yes, sir.
Okay. Is there any further discussion? Yeah, Senator Morrissey.
Senator Cosgrove,
Yes, sir.
intuitively, it seems to me that this bill is practical, but can you address a question that at least a couple of us have talked about, and that is the following. When you're going to purchase a property or sell a property, there's a concept known as a title search and title insurance.
Right.
Where does that enter the formula with what you're trying to do?
Mr. Chairman, I answer the gentleman. The original bill, as originally presented, would have required a title search on any deed of gift. Now, there was a lot of pushback from title companies and real estate transaction lawyers that it would have been too much of an imposition, especially at tax time when there are many deeds of gift because of tax purposes. I like the title search thing, but I tried to come to agreement with all the stakeholders to find something that wasn't quite as heavy-handed. I would prefer a title search, but again, there's additional money and additional time that's taken in that.
Follow-up question.
Senator Morrissey.
But as I read the bill, it says, no clerk shall record a deed of gift unless such deed is accompanied by a document certifying that a title search has been completed.
That was the original bill.
And that language is, that specific language is
That's been
out?
deleted. That's,
Yes.
okay. Anybody want to speak in favor or against? Okay.
Mr. Chairman, members of the committee, Jeff Palmer on behalf of the Virginia Bar Association, and I've spoken with Chip Dix with the Virginia Court Clerks Association this morning. This amendment, we just haven't had time to circulate it among our membership
Want to pass it by for the day?
yet, so.
Without
that's-
objection, the bill will be passed by for the day.
Thank you, Mr. Chairman. I would just ask them to please move expeditiously. They have been working on this for a couple of weeks and can't seem to get the right thing going. So thank you for taking
All
it by,
right.
sir. Appreciate it.
The next speaker, Senator Lewis has asked that his bills, two bills, go by for the day. Senator Lewis's bills will go by for the day. Senator Steph is in the line. Is Senator Steph here? All right, Senator Locke.
Thank you, Mr. Chairman, members of the committee. I have Senate Bill 956.
Senate Bill 996?
956.
956.
And what Senate Bill 956 asks is, it asks to amend the code as it relates to the Fort Monroe Authority regarding civil actions in General District Court. The Fort Monroe Authority is responsible for approximately 300 acres of land with 1.5 million square feet of buildings. The economic model for the Fort Monroe Authority includes both the management and leasing of these facilities to private individuals. Although there are very few problems with tenants at Fort Monroe, when a problem occurs, the authority reserves the right to go to court. And the code allows business entities to prepare, execute, file, and serve in General District Court a number of landlord-tenant related filings. Since the authority is not one of the business types listed in the code, in a recent filing, the court threw out the authority's warrant in a debt filing. So what the authority is asking for is the ability to be able to go to court and in these related filings.
Okay. Is there
Move
any
to report,
question?
Mr. Chairman.
Yes, Senator Norman? Sorry.
Move to report.
Been moved and seconded to report Senate Bill
Mr. Chairman.
956. Senator Senator Obuche?
Mr. Chairman, I understand the patron's concern, and I see Fort Monroe marching up the aisle behind her. And, but, you know, we've dealt with this issue and similar issues over, you know, the 16 years I've been here, and have resisted the temptation pretty consistently to allow the practice of law by non-lawyers, which really this is. And the Supreme Court has addressed this multiple times. We have had situation where Division of Child Support Enforcement was routinely drafting pleadings without their attorneys, and we've declined to extend this authority. And I just am concerned about the precedent this sets for other agencies and organizations, and the impact this has. And it's not just as a lawyer worried about, you know, my profession or protecting the profession, but we've got an obligation to, as members of a profession, to fulfill certain obligations of good faith that aren't imposed on non-lawyers. And what we're talking about here is allowing non-lawyers to file pleadings to seek the entry of judgment, and they don't have some of the same obligations of good faith or the means to enforce those obligations of good faith, and could affect the litigants on the other side of this as well. So with respect to the patron and the hardship that this seeks to address, I just think this is a bad precedent that we ought to consider resisting. in this and other instances.
Okay, any further, is that a question? All right, it's been moved and seconded that the bill be reported. All in favor, it says incorporate.
Mr. Chairman, I'm
Yes,
sorry.
Yeah, Senator Sherrill.
So I've just been trying to look through the code here to try and figure out the last time that we expanded this authority to another entity, and I'm back to 2000, right now I'm back to 2004 and still haven't, amendments to this code section haven't found anywhere where we've expanded this Christmas tree, so it looks to me like maybe council's shaking her head at me, maybe I'm wrong, but it's looking to me like the Christmas tree hasn't grown since maybe the 90s, I don't know, maybe, could she correct me about that?
Mr. Chairman, Senator Servo, the last time I see that it was amended was to add the Department of Military Affairs in 2017.
Okay.
2017, all right.
Okay, but before that, I'm not seeing anything back to
there
early
a question,
like
or-
90s.
Any comment, further comments? It's been moved and seconded that the bill, Senate Bill 956 be reported. All in favor of the motion, vote aye. All opposed, vote no.
Did you vote me? Did you vote me?
Ayes 9, no 6.
9-6, the motion carries. Okay?
Thank you.
Thank you, Senator Locke. Senator Howell, is she here? Senator Marsden, is she here? Okay, Senator Steph, okay.
Mr. Chairman, members of the committee, we have two bills, should be pretty quick, and they're pretty easy. The first one, Senate Bill 985, and what this bill does is says that in any litigation in which the constitutionality of the Commonwealth is challenged and the court finds the law is unconstitutional, the Commonwealth shall reimburse the aggrieved party for attorney fees and costs. Happy to answer any questions on it.
Any questions? This is the standard American rule is you pay your own attorney's fees. The English
Chairman.
rule is loser pays.
Mr. Chairman.
Senator Sherrill.
Thank you. I'm asking a question of the patron as to whether or not you care whether it's unconstitutional under the U.S. Constitution or the state constitution.
Doesn't matter. Unconstitutional, period.
Mr. Chairman, further question.
Senator Sherrill.
How would you square that with the liability the Commonwealth has under 42 U.S.C. 1988 for 1983 actions, which do the same thing?
I have no clue. I'm not an attorney. I don't know that section of the code.
Senator,
I'd have to have staff comment on that if there is a
Senator-
comment, but I don't practice law.
Senator, where did this come from, this idea? What's the fact situation that gave rise to the bill?
I had constituents come to me and say that in the past, we've challenged the constitutionality of some of the things the Commonwealth has done. We've won on one or two of these, and we've not been reimbursed for our legal fees.
Okay.
I said, we certainly should be able to fix that. If an aggrieved party challenges the Commonwealth or anyone else and they win,
Yeah.
they should have their legal costs covered.
Senator, the standard is if you pay your own attorney's fees, the only time there's a cost shifting is if the contract, like a note, specifically provides attorney's fees to the person, the defendant, or there's some statutes, civil rights statutes and the like. And that's
Mr.
about
Chairman,
it.
I put it in every business agreement I do it. I put it in every lease I do.
Then
And if I win,
then
they
you
pay
get
the
it.
court
If
costs.
it's in a
Mr.
written
Chairman.
contract. Yes,
Lawyer
Senator
fees.
Sherrill.
Thank you. So in the contracts that you do, it says only you get fees, or it says the prevailing party gets fees, which is what the standard is under 42 U.S.C. 1988 when you're bringing a claim for something violating the U.S. Constitution?
on one of the contracts I do, it says that I get the fees regardless. On another one of them, it says the prevailing party does.
Right.
All right, is there a motion? Any further discussion? Is there a motion?
Mr. Chairman, I would reluctantly suggest that we pass this bill by indefinitely. It's got a lot of potential issues.
Is there a second? All in favor of the motion to pass it by indefinitely, vote aye. All opposed, vote no.
Mr. Chairman, members of the committee, thank you very much.
Yeah, thank you. You have another one?
Next, we have 1002. We refer to it as moot courts. And, Mr. Chairman, what happens today is the Court of Appeals judges use courtrooms of accredited law schools located in the Commonwealth, but they can only do it at public institutions. our Court of Appeals is a traveling court, as you all know, and they'd like to be able to use it at both public and private. So Regent University, William and Mary, UVA, George Washington, all the other law schools in the Commonwealth. And again, they're only allowed to do it at
Washington and Lee.
UVA, George Mason, and Marshall Wythe Law School.
Is this requested by the Supreme Court? Or is this requested by the courts?
Yes, it is.
Okay, any questions? Is there any discussion?
Move to report.
It's been moved and seconded to report Senate Bill 1002. All in favor of the motion, vote aye. All opposed, no.
Mr. Chairman, members of the committee, thank you very much. Have a great day.
15-0, the bill is reported. All right, Senator Martin, I think was next, or Senator Howell. Okay, Senator Howell.
Thank you, Mr. Chairman. I have once again Senate Bill 581.
Okay.
This
Bill
is the bill.
581.
This bill deals with child access to firearms. And as I mentioned before, the goal is to try and prevent teen suicides. And we're averaging about 30 a year that might be saved by this bill.
And there's
I
a
have some.
substitute. There's a substitute?
Yes, I guess it's a substitute. It has two provisions different from before.
Mr. Chairman.
Okay. It's been moved and seconded that the substitute be adopted. All in favor say aye.
Aye.
All opposed, no. Motion carries. Okay, what's the difference?
Okay, the first is that it's now a Class 1 misdemeanor instead of a felony.
Actually, we'll have to have a line amendment to that. It says Class 6 felony here.
They didn't change it? Well, I had wanted it changed to a Class 1
Yeah,
misdemeanor.
Mr. Chair, that amendment just came in this morning, so that would be a change on the substitute.
Okay.
So line 14 at the bottom where it says 6 felony, Class 6 felony, change that to Class 1 misdemeanor.
That's correct, Mr. Chair.
Okay, is there a line amendment, is there a motion to accept that?
So moved.
All in favor say aye. All opposed, no. Line amendment's adopted.
Thank you.
Okay.
Then the more perhaps substantive part is trying to address concerns that it would impact hunting. We have specific language that says this subsection shall not apply to conduct in the course of hunting and trapping, as that term is defined in 29.1-100 by lawful means and in a lawful manner.
Mr. Chairman, if I could help,
Okay, Senator Steve Benjamin.
I'm just a lawyer. The substitute before you has an earlier option that staff had worked on, but we thought better as we continued to work on this on the language that Senator Howell has now mentioned. And so our suggestion, and the problem with the language that's now in the substitute is it implies that it's okay to recklessly handle a firearm during hunting. And so to avoid that implication, looking at the substitute before you, you would strike the new language on lines 11 and 12, and at the end of that subsection, you would insert the language that Senator Howell has used, and that language would be as follows. This subsection shall not apply to conduct in the course of hunting and trapping, as that term is defined in section 29.1-100, by lawful means and in a lawful manner.
Okay, is there a motion to adopt that line amendment?
So moved. Second.
It's been moved and seconded that line amendment be adopted. All in favor say aye.
Aye.
All opposed, no. The line amendment's adopted. The bill is, the substitute's in good shape, I
Mr.
believe.
Chairman.
Yeah.
Mr. Chairman.
Yeah, Senator Serval.
So I'm trying to just think through this. So right now, under existing law, if we don't do anything, it's unlawful for any person to recklessly leave a loaded, unsecured firearm in a manner to endanger the life limb of any child under 14. So we've now pushed that to 18, but excluded hunting and trapping. So there's hunting and trapping behavior involving reckless firearm use that's currently criminalized, and now we've just taken it out. Am I right?
That's right.
So, I mean, just, Mr. Chairman, it strikes me that the hunting and trapping exception now may sweep too broadly, because now it immunizes conduct which was formerly criminal. I mean, I don't hunt, but it just seems to me there might be maybe somebody who does hunt could explain to me, but it seems to me there might be situations where somebody could recklessly give a firearm to a 12-year-old while hunting, which could endanger life, limb, or property of somebody and be guilty of a crime, and now there's no crime. Am I missing something, or?
Mr. Chairman, Senator Surville, I think that under the current statute, because it speaks of recklessly leaving a loaded firearm, that would not in any instance apply to hunting. And so quite frankly, we didn't think that the additional language was necessary, but to clarify and make it patently obvious that this bill does not apply to hunting, that's why the new language has been added. I don't think that the existing statute applies to hunting.
Okay. Any questions? Anybody want to speak in favor of the bill?
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. The word recklessly is the most important thing people should be listening to here. Recklessly already exists. It's just changing the age and upping the penalty. Thank you.
Okay. Next.
Mr. Chairman, Alexander McCauley on behalf of the National Alliance on Mental Illness, and we support the bill.
Next.
How long do I have?
About 30 seconds.
Okay. Dr. Barbara Boardman from the Academy of Pediatrics. We strongly support this bill. We specifically want to speak to the issue of age 18. We see this as a suicide prevention bill. 79 children under age 19 killed this year. In 2017, 40% of them were suicides. Another 8% are those so-called unintentional injuries that shouldn't happen. Most guns that children engage in, either suicides or accidents, are in the home or in the home of friends and family. I could give a long talk about prefrontal cortex and how they're important, and kids are spontaneously done. I've even been at gun shows where people said under 18 is crazy. We're professionals. We believe in science-based, evidence-based, and we've presented all of that to your committee. We really think that this is part of a program of prevention of childhood injuries that are really important to us. We're the ones who see this. We don't want to see adolescent suicide. We don't want to see unintentional injuries. We don't want to see community violence. We do see this, and we don't need to have it happen.
Okay, thank you. Now we have the Secretary of Public Safety and
Chairman,
Homeland Security.
Members of the committee, we continue to support legislation. Thank you.
Good morning, Tanya Shar on behalf of Brady. We support this bill.
Okay.
Good morning, Lori House with the Coalition to Stop Gun Violence, and we support the bill. We know that in the Commonwealth of Virginia in the last decade, 139 children, that's 139 children died by firearm suicide, and another 24 died of unintentional shootings. Strong child access prevention laws are associated with a 26% reduction in firearm suicides among youth. We wholeheartedly support the bill. Thank you.
Okay. Next.
My name is Jonathan Romans. I'm a gun violence prevention advocate here in Richmond, Virginia. Just wanted to mention to all the senators that the NRA itself, through its own government, has gun safety rules. And in those rules, it recommends that gun owners do lock up their own guns when not in use. It does fulfill one of the basic purpose of laws, which is to promote this good behavior. Yes, I support the bill. Thank you.
Okay. Next.
Dodd Mark with Giffords. We support the bill.
Okay. Anybody else in favor? Anybody against the bill?
Philip Van Cleve, VCDL. The Class 1 misdemeanor is okay. It's just the 18 that bothers us. We think we like the 14 the way that was, the increase in the penalty.
Okay. All right. Next. Thank you.
Patricia Webb, Hanover, Virginia. I'm opposed to this bill because
of the lack of definition of irresponsible leaving the gun or recklessly leaving the gun. So if I were to give my under 18 child access to a firearm to defend themselves while they were at home alone, assuming that they're responsible, I'm, as a parent, should be able to make that determination. Would that then put me in violation of this law? I think it should be up to the parents to determine. Obviously, if somebody puts their child in danger, we already have laws about that. I would also say that the vast number of suicides, if you take away the gun, they still find other ways. So I think we need to look at mental health issues instead of the tool that they use for that. Thank you.
Okay, next. Thank you.
Good morning, Mr. Chairman. DJ Spiker, National Rifle Association. While we support the patrons' sentiments and what this bill is trying to do, our concern is the unintended consequences. The number of amendments here have obviously improved the bill, but that said, the amendments, it has to be this amended this much. Leaving it as is, current law penalizes reckless behavior and unsecured loaded firearms. We don't need to change it. We don't need to increase penalties. As is, the bill is as is, the code is fine. We don't need to be changing that, so we oppose the bill. Thank you.
Okay, next.
Good morning, ladies and gentlemen. My name is Richard Pyle. I'm a citizen of Dinwiddie County. Currently, Virginia law for a minor to hunt unattended is 12 years old. My son, being 15 years old, has a shotgun in his room. He has ammunition for it. He can go hunting when he comes home from school without my permission or supervision. He's very capable of that. He's been doing it since he was 5 years old. If this law, as I hear it now, I would be guilty of a Class 1 misdemeanor if he were to have some sort of an accident at home, or even because it says leaving it unattended in a manner that could. Am I correct? Could I ask that question? That would make me guilty of a Class 1 misdemeanor just by leaving that with him.
To endanger life or limb, yeah.
So that is a contradiction in the Code of Virginia if you pass this. Thank you very much.
Okay, thank you.
Will Shaw, I'm a resident of Louisa County. Real life is when my son was 16, he came home from school, and thanks to having access to a loaded firearm, was able to interrupt wild dogs attacking our livestock. Under this law, I'd be risking a year behind bars for allowing him that access. I think the age ought to be 16, not 18.
Yeah, Senator, sir, it says if you recklessly leave a loaded, unsecured firearm in such a manner as to endanger life or limb of any person under 18.
The term recklessly is, I think, a little squishy.
Sure, okay.
I still think the age should be 16.
Okay, thank you. How you doing?
Pretty good. My name is Joseph H. McClung from Rich Creek, Virginia. I'm against this bill. I'm president of a gun club. And gun clubs, you teach young people how to use a firearm safety. This bill you have here does not address gun clubs or shooting ranges public shooting ranges where people can train people to use a firearm properly. And so I'm very much against this. Thank you. Okay. Any questions?
You could still have a gun club and teach teenagers.
You can't. I want to add something else too. Suicide. Yeah. Right. You cannot pass laws to make. You can't pass laws to make insane people sane. You can't pass laws to stop sane people becoming insane. I mean, that's. I mean, suicide. Been with us from day one.
Sure. Okay. Thank you.
Thank you.
Appreciate it.
Good morning. Mariah Rowland, Louisa County. We oppose this bill. We have a 15-year-old at home who has been properly trained with firearms, knows safety and how to use them. And I leave him with firearms when I leave in the event that he needs to defend our home, our property, or our animals. This is going to make us criminals for leaving a well-trained individual with the ability to use a firearm to defend himself. I understand that it says reckless, But who is going to decide if it's reckless for him to be 15 and with a firearm? Is it going to be when there's an accident? Is it going to be if there's somebody who's breaking into the house and he defends himself? When that happens, am I going to be charged? So we do oppose this bill.
Thank you.
I'm John Quapis from Chesterfield. First, I have a point of information or inquiry. The bill says recklessly in such a manner as to endanger life and limb. What exactly do you mean by recklessly? Give some examples. And what manner endangers life or limb? Can the sponsor answer that? Or can anyone here answer that? Or do we leave that up to subjective impressions of people?
Mr. Chairman, it might be helpful to point out that we have a number of crimes on the books that require the state of mind of recklessness. And that term has been defined in the criminal code as reckless driving, for example. And so to give an example, none of the speakers today, Mr. Chairman, would have described situations that I think any of us would consider reckless. If you have a very well-trained 15-year-old who can be entrusted with a loaded firearm, then that is not what is prohibited by this statute. What this statute would prohibit, for example, would be if a child suddenly locked themselves in the room for days on end, refused to eat, showed evident signs of depression, maybe tried to take their life with an overdose or some other instance. For a parent under those circumstances to leave the house and leave behind the despondent child locked in their room with a loaded firearm sitting out in the living room somewhere, yeah, that would be reckless.
Mr. Chairman.
Mr. Chair.
I would suggest that maybe Mr. Benjamin is citing a clear case of recklessness, and that the standard for recklessness is going to vary from one part of the state to another part of the state, irrespective of the background of the people involved, the level of training, whether they have moved from a rural part of the state. And I think that it is probably a lot less clear than the clear example that Mr. Benjamin, with great respect that I have
Mr.
for
Chairman,
him, points out.
Mr. Chairman, Senator Obenchain, it's a fair point, which is often made when the committee enacts criminal statutes. And the answer is, this is why we have elected Commonwealth attorneys from each jurisdiction whose discretion we trust, why we have juries from the jurisdiction that we trust, and why we have judges that we trust, in order to, as objectively as possible, consistent with the law, apply the mens rea, the mental states that we require in order to prohibit particular conduct.
Yeah, Senator Peterson.
Yeah, and I appreciate Senator Benjamin's advocacy, but let me just make a couple points. No child can be trained until they actually have used a firearm. That's how you train a child. And if I take my teenage daughter, maybe we're at the Homestead, maybe we're at Isaac Walton League in Centerville, and we take her out and use a firearm for the first time. It's a loaded firearm at that point. Now, I may be standing next to her and helping her, or there may be a range guide or somebody, but there's a first time. And so this presupposition that someone can only handle a firearm if they're well-trained, well, that's one of the ways that we train children. And first of all, I appreciate that it's no longer a Class 6 felony, and that's critical, okay? That is critical. But I still have the fact that a child is 15, 16, 17 years old, and you have a family that uses firearms and has a tradition of hunting or what have you, and if you take a child to a range or any situation, and maybe a controlled situation, that suddenly, again, we're now making this a crime where before, or potentially a crime where before it was not. I just feel like, we've done a lot with guns this session, a lot. But I think we're starting to get more into intra-family dynamics than we are firearms.
Okay,
Mr. Chairman?
Stewart.
Okay.
Senator Stewart.
And to Senator Peterson's point and Mr. Benjamin's point, I actually think what you're going to see in this ending up being is a per se statute. Because if someone And suicide was talked about here, and if that person gets that gun and uses it to commit suicide with, first of all, I don't know how you prove the case, but they're going to be prosecuted under the statute because the gun was left in such a way that that person could use it to commit suicide with. And it becomes very complicated after the fact. But what troubles me even more about this bill, it is perceived that we've eliminated hunting and trapping activity, but it's only if you're engaged in that. And so I think what this committee first looked at was they thought they were removing hunting guns and guns you use in trapping, but you're not, because if those guns are around, you still could be prosecuted for that offense as well. And it just, to me, you can drive a car at 16 years old. At 16 years old, and that's about the most dangerous weapon in the world. You can kill yourself and God knows how many other people, but now we're going to limit guns to people 18 years of age or over.
Excuse me.
Okay.
I'm not done, but
Senator Howell?
I'll yield
You
to a minute.
you want?
He says he's not done.
Okay, go ahead. Continue.
Thank you, Senator. I would just offer a couple suggestions. One is that I think the age should be reduced to 16, not 18, because I think some things that have mentioned here. And also, if this goes through, maybe there should be an exemption that says if that gun is used in self-defense or to defend the property in case the dogs, the wild dogs, et cetera, that this would not apply. You might also say that the individuals, the young people should have if they had a certification of training, that therefore this would not apply in that situation either. Thank you.
Okay, thank you. Senator?
Mr. Chairman,
Senator Howell?
I just wanted to point out that most of what is being discussed here is existing language.
Right.
It's already a reckless standard, and all that is really changing is the age to go from 14 to 18 to have that same standard that we've had for God knows how many years.
And Class 3 to Class 1 misdemeanor. Yeah.
Well, that's now staying the way.
Well, no, it goes.
Oh, I'm sorry.
The
Yes,
original
3
language,
to
Class
1.
3 misdemeanor. This is making
I'm
Class
sorry,
1
you're right.
misdemeanor.
I'm sorry.
So, okay. Anybody else have anything to say?
Mr. Chairman, if I may address one of Senator Stewart's comments, the committee should bear in mind that criminal statutes are always construed strictly. And the existing law, as Senator Howe has pointed out, applies, number one, to recklessly, and number two, to a firearm that has been left. A firearm has not been left if the parent is there present with the firearm. But speaking to recklessly, if an individual is driving and then falls asleep and crashes and kills people, the question is that reckless driving? The fact of having fallen asleep does not make it reckless driving. It becomes reckless only if that individual was on notice that he was getting sleepy, that he hadn't slept for a long time, and that he was likely to fall asleep. That is an example of what the criminal law requires when you have that state of mind requirement of recklessly.
Okay. Is there anybody else who would like to speak? Go ahead. I'm sorry. You have a late gentleman here who would like to say something?
Oh, sorry.
I'm John Pulliam, live in Fluvanna County. I've taught all four of my kids how to hunt at a young age, and doing the hunter safety course that's in there says that we need to have them trained so that they can hunt at age 12. You know, here you're going to sit there and say kids can't do it. I understand the whole gist of your point here is to try to eliminate young suicides, but you know, they can do it any other way they want. I mean, we can't even get rid of the drugs that kill kids. You know, they know how to OD. You know, the other one is that we really want to take the parent out of the picture, because once that kid gets a hold of a gun, commits suicide, now you're gonna classify felony for the parent. Hadn't the parent already suffered enough? I mean, I understand a little bit, maybe, the lesser degree than a felony, because I've already lost one kid, I know that pain. And to have a felony on top of that, are you really thinking? That's almost like unusual punishment.
Okay. All right,
So-
go ahead. Senator Deeds is not here, and he's in local government. We might want to take it by until he gets here, but go ahead. Each of you, we've spent a lot of time on this.
All right, thank you.
Go ahead and say very quickly what you want to say.
Mr. Chairman, Senators, Cody Stowe, Sergeant First Class, United States Army, retired. Just the age limit's a little too high. You're able to join the United States military 30 days before your 17th birthday. So with that being said, that's that speaks a lot.
Okay.
So,
Thank you.
Good morning. I think we're playing a bit fast and loose with the word reckless. Here in Virginia, it's pretty common. I don't think there's anybody in this room who doesn't know somebody who hasn't been nailed under the reckless driving statute. And I would defy anybody in this room to explain to me how doing 80 miles an hour on the freeway when it's perfectly nice outside is a reckless act.
Well, this is a gun. This is a gun. It's not driving. Okay, next.
I wanted to add one point about suicide and guns. The most popular forms of attempted suicide are cutting and pills. These attempts are successful less than 10% of the time. By contrast, suicide by gun, which amount for less than 10% of all total attempts, are successful more than 90% of the time. So yes, the method does matter. Thank you.
Mr. Chairman, move to report.
Okay. Motion's been made.
Mr. Chairman.
To report. Is there a second?
Mr. Chairman.
Okay, yeah, Senator Sherrill.
Thank you. I would ask the bill go by temporarily so that somebody who's not here can take account of the amendments that have been made to the bill.
Okay. All right. Without objection, we'll pass it by until Senator Deeds gets here.
Mr. Chairman, would it be all right if I'm not here when you do that? I've got to be upstairs.
That'd be fine.
Thank you.
That'd be fine. Okay, moving on to the next bill. Where are we? Let's see, do we have Senator Marston? Is he here? Okay. All right, Senator Marston, yeah.
Thank you, Mr. Chairman. Senate Bill 1015.
Senate Bill 1050?
1015.
1015.
1015.
Thank you. 1015. All right, Senator Marston.
Thank you, Mr. Chairman. What this bill essentially does is as you remember, when we created the 5 medical processors in Virginia, we created a registration system where people could get a recommendation from a physician on a form to qualify for CBD and THCA oils that these processors would be manufacturing. And we created an affirmative defense for these parents and their children, because as you remember with the first bill, it just dealt with intractable epilepsy. We've since expanded the bill, to deal with people with any condition that a physician feels that these products would be helpful for. And what this does is, I think at the time we did the bill, people were somewhat nervous about it, and so we put in what's called an affirmative defense. In other words, if you got arrested for this thing, you had a sort of a get-out-of-jail-free card that you could play. Problem with that is, Mr. Chairman, is that the arrest takes place, it's picked up by a record-checking company, and you're haunted the rest of your life, even though you're granted the affirmative defense and they drop the whole matter. It still gets into the system somehow, and what this does is basically make it so that the possession of lawful CBD and THC oils in keeping with this program as a patient, parent of a juvenile or an incapacitated adult, or employees of the pharmaceutical processors that are producing these oils are not subject to arrest for these oils to begin with. They don't have to provide the affirmative defense. They are just operating within the law.
Any questions of the patron? Okay. Anybody want to speak in favor of it? The bill? Senate Bill 1015.
Good morning, Mr. Chair, members of the committee. Jen Michelle Bedini on behalf of the National Organization for the Reform of Marijuana Laws and the state affiliate Virginia Normal. We support the bill and think this is a much needed measure. Thank you.
Okay. Anybody else in favor of the bill? Anybody against the bill?
Good morning, Mr. Chairman, members of the committee. My name is Wes Nance, Commonwealth's Attorney for Bedford County, speaking on behalf of the Virginia Association of Commonwealth's Attorneys. We are opposed to this bill because we believe that the affirmative defense statute, as it is presently written, is an effective way to enforce individuals that have the written certificate. We're afraid that if there is no arrest or no allowment for prosecution under this, a full investigation will not be allowed to be done. An officer or trooper or deputy on the side of the road will have to try to determine whether or not this written certification is valid or not. And that's why we would oppose the bill. Thank you.
Okay, thank you. Anybody else, any questions?
Mr. Chairman, I have a question.
Yeah, Senator Serval.
So, I mean, I think I agree with the intent of the bill, but my question for the patron is similar to what you just heard a second ago, which is, how is a law enforcement officer supposed to know that somebody has a valid prescription, or I'm sorry, valid recommendation if the person doesn't have it in their possession, right? Because, I mean, you stop somebody, you find the oil, they say, well, I got the recommendation, and the officer's like, well, where is it? Oh, it's at home. So if the officer arrests the person, they've broken the law. If they don't arrest the person might be lying to them and breaking the law and lying about whether or not they really have the recommendation or not. So how does the officer make that determination on the side of the road or wherever they're encountering them?
Well, I think Senator Serval, if they want to, as long as they don't make that arrest and they can wait until the person delivers that to them or produces it for them, I think that's what works. What you're doing here is, if they go ahead with the arrest, that stays with you forever. Even if you've just left it at home, you go get your certification, they drop the case, and it's on every record check company's database. And
Mr. Chairman,
it's going to interfere with your ability to get employment, and there's just no need for it.
Yeah, I mean, I get all that, and you can always get an expungement if you're innocent, which also costs money. But in any event, I mean, we already have this situation with people get charged with illegal possession of prescriptions, right? And the difference is the prescription bottle has your name on it. I mean, typically, when people carry around the prescriptions, they carry it around in the pill box, the pill bottle, which says their name and who prescribed it and where they got it. I don't know about this THC stuff, about how that comes, but I mean, it just seems to me that if the THC stuff comes in a prescription bottle and the person is possessing it in the box or whatever that it came in, it'd be a hell of a lot easier, or a whole lot easier for a law enforcement officer to make that decision on the scene, but the bill doesn't cover that scenario. Maybe counsel, I see.
Thank you, Mr. Chairman. Senator Serval, bear in mind that the officer doesn't have to arrest in order to initiate the charge. The officer could issue a summons, and then the person has not been arrested.
Okay, all right, go ahead.
To Senator Serval's question, yes, they are being dispensed by pharmacies, so it will come with that same information that a regular prescription would from a regular pharmacy, as well as the card that is issued by Board of Pharmacy has explicit instructions that they are to keep this on their person and with their medicine at all times.
Another question for.
All right, last question. Senator Serval.
Sorry, so is there like a label on a bottle, or does it come in a box and there's a bottle in a box and the bottle doesn't have like the stuff on it, the information on it?
It's going to differ by each product.
Okay, all right. Yeah, Senator Morsi.
Quick question for the patron, or perhaps staff. In subsection C, line 29, it talks about no person shall be arrested or prosecuted, et cetera. A rather, I think, unusual form of language as opposed to the normal language that this committee would see, such as nothing in this statute shall prohibit a person from possessing THC oil if they have the document. Why wasn't it written that way so as to not conflate issues of arrest and prosecution?
Senator Morsi, that challenges my memory from 5 years ago when this was put in. But if the senator is willing to suggest less complicated language, we could certainly take it by for such an amendment.
Well, I'm going to ask
Senator Morsi.
Get a sense from staff. Normally, we would see something like this. Nothing in this statute shall prohibit a person from possessing the cannabidiol oil or THC oil if such person, and then just has that language, does that, do you consider that a friendly amendment in the staff? Is that workable?
Mr. Chair, I think the intent, and I'm not trying to speak for the patron here, but I think the intent was to provide explicit instruction that no person shall be arrested. Under your language, it still suggests you could be arrested, and then when the person produces the instrument, that's when the charges would drop. I think that is why this language was chosen, was because of the explicit language regarding arrest.
One final comment, Mr. Chairman, and then I think we might want to pass it by temporarily. First of all, the police officer coming up does not know, he's not part of the Bureau of Forensic Science, what type of oil it is. He may be able to do a test for THC, but it's still not prohibiting a police officer from arresting somebody if they think they have a controlled substance. So my motion would be is it doable to pass it by for the day or pass it by temporarily, given that we're fast moving towards crossover? Day?
The will of the body, I mean. Senator Martin, do you have any?
You know, if Senator Morrissey feels like he can work with staff to improve that language, but the bill is very, very important to get this out of the affirmative defense. Who in the world is going to work for a pharmaceutical processor where you could be arrested pending an affirmative defense? You know, you might do that if you risk that if your child is at risk for
Mr. Chairman, Senator
tractable epilepsy.
Senator Stewart.
And this may be a question to Senator Marsden, or it may be to staff or Mr. Benjamin, I don't know, but even if you proceed this way, you still have the difficulty of search and seizure and other issues that come along with the fact that marijuana and its derivatives are criminalized. Is there any way to legalize CBD oil? It's not used for any other purpose than medicinal purposes, is that correct? I'm asking an honest question. Because that takes it out of the criminal prosecution realm, and I'm not aware that people use it like they smoke pot. I don't know the answer.
Senator Stewart, I think it would have to be written in such a way that anything that is lawful, you know, based on what our pharmaceutical processors are allowed to produce, that would, you know, taking that out of the making it lawful, making that product lawful, could potentially work.
Mr. Chairman, and the reason I ask this question is I don't know why we would go to great pains to create defenses, bars to prosecution if we could just legalize the oil. I don't know. That's just for the.
It can't be turned into a hallucinogenic. I don't know what the big deal is.
What happened, Mr. Chairman?
Just final thing, Mr. Chairman, is that I don't want people to go through the pain of an arrest for having medicine for their child, or their incapacitated adult parent, or even themselves, and having this end up on somebody's database somewhere. And this makes sure that won't happen. You know, police officers can do their investigation and come back and make an arrest at a later time if they think they're being scammed. But and perhaps there's a better language to say that. But this bill is very important, especially for the pharmaceutical processors and their hiring of people.
Mr. Chairman, I have a motion. The motion would be to pass this by for the day to allow staff and members of the committee and the patron to work on it. We have at least two concepts. One, to legalize possession of THCA oil, and second, the amendment that I suggested. So that would be my motion if there's a second.
All right, we have a motion before us to carry it by just for the day. All those in, voice vote. All those in favor, say aye. Opposed?
Thank you, Mr. Chairman.
All right, it's carried by for the day. Senator Hashmi, you're up.
Thank you, Mr. Chair. For SB 408, we have a request to pass it by till Wednesday while we continue to work on some amendment language.
All right, it's been moved and seconded that Senate Bill 408 go by for the day. All those in favor say aye. Opposed? All right, it's by for the day. You have 1032?
Yes, it's SB 1032.
All right.
And this bill seeks to assure that there is a consistent application of civil court fee waiver request. SB 1032 would make the application process simpler for all low-income civil litigants while also easing the administrative burden to the courts. The problem that we currently have is that recent changes to Virginia's fee waiver statute have, despite their very best intentions, resulted in unequal access to Virginia's courts for low-income persons seeking civil justice. So what we are trying to do is to ensure that the presumption for all low-income civil litigants who receive public assistance and thus within the court's indigency calculations would save time for court personnel. And we also, that the presumption for legal aid clients, it includes that those represented by attorneys through legal aid are already pre-screened to assure that they satisfy the same poverty threshold that the courts use. And finally, there is no fiscal impact with this change. In 2017, the DPV determined that the similar bill language as filed would have no material impact on the state's budget. And in 2019, the bill's fiscal impact was indeterminate. So in essence, the key point for SB 1032 is to increase access for justice for all low-income civil litigants while also reducing the administrative burden for the courts.
Any questions of the patron? Okay, thank you. Who's in favor of the bill? Step right up, very quickly. No.
Thank you, Mr. Chair. Valerie LaRue from the Virginia Poverty Law Center. And this committee saw this bill last year, made a very narrow application of the bill. And this bill, I think, seeks to both address some of the issues that were brought up last year and also extend it, as the senator says, to make things easier for both litigants and the courts.
Okay,
thank you.
Next.
Good morning. My name is Jerry Greenspan. I'm a pro bono attorney with Hunt and Andrews Kurth in Charlottesville, and as a practitioner representing low-income clients, particularly in uncontested divorce cases, I just want to let the committee know that I have seen these issues in practice, and I do believe that the bill would fix them and open up access to the courts to everybody.
Okay, thank you. Next, anybody else? Anybody against the bill? Is there a motion to report? All in favor? It's been moved and seconded to report the bill. Needs to go to finance? Okay. Motion is to report and re-refer to finance. All in favor of the motion, vote aye. All opposed, no. Motion, go ahead.
Ayes 15, no zero.
Ayes 15, no zero. The bill is reported and re-referred to finance. Thank you, Senator.
Thank you.
Okay, the next is Mason. Okay. Senator Mason.
Hey, bud. Thank you, Mr. Chairman. Good morning, sir. Members of the committee, if we could start at Senate Bill 670. You saw this one last year. The goal here is if someone appears and is unrestorably incompetent, so dementia, Alzheimer's, it has been noted that they've been in this condition. I mean, it's very clear. Heretofore, they have to have a separate hearing. Go back and have it determined whether or not they are, in fact, unrestorably incompetent. We tried to just cut to the chase here last.
Mr. Chairman?
Yeah, Senator.
Didn't this pass out unanimously?
It did, yes, sir. It ran into, shockingly, it ran into a glitch on the other side, which we fixed over the summer, Mr. Chairman.
Unless there's any opposition that wants to raise any new issues, I would be inclined to move to report.
I'd appreciate it very much. Thank you, sir.
Discussion, doesn't have to go anywhere. All in favor of the motion to report Senate Bill 670, vote aye. All opposed, no.
Ayes 15, no zero.
15 to no to zero. The bill is reported.
Thank you, Mr. Chairman. Next, Senate Bill number 684. So currently, this was brought to me by one of my local Commonwealth attorneys. So if someone is involuntarily committed and at the time says, I want to appeal, okay, so you put them in the appeal process. It's going to go to the circuit court. It could take 14, 20, 21 days. If in that period of time, the person is restored, 7 days later, they're good to go, they're released and restored, then they get docketed and come around to court. as I understand it, the judge can only determine, are you currently, as you're standing here in front of me, competent? That's the only ruling that can be found. So if it went through the normal course, you'd have that ruling that you are competent, but then there would be a separate discussion about, about restoring your gun rights. Today, when the judge says, yes, you appear to be competent, you're good, all of that happens at that point. And the Commonwealth's attorneys just wanted an opportunity to have the same hearing that they have today to determine, in fact, are they ready to get their gun rights back? That's what this attempts to do, Mr. Chairman.
Okay, you have a question, Senator Morrissey.
Senator Mason, the current process is that if an individual wants to have their gun rights restored, they first have to have their civil rights restored.
Yes, sir.
And then they have to file a petition in the circuit court where they reside to have their gun rights restored. And in there, that is the hearing that would bring up whether or not the person has certain mental health issues. And the Commonwealth is always a party to that litigation.
Yes, sir.
So not meaning any disservice to the bill, isn't that already covered, and aren't you satisfied with aren't the Commonwealth attorneys satisfied that a petition for the restoration of gun rights is already an adversarial process in the circuit court with the Commonwealth attorney and the individual involved?
Mr. Chairman, Nathan Green, Commonwealth's attorney for the city of Williamsburg and James City County. I'm here speaking as just that for Williamsburg and James City County, not on behalf of VACA. We are not talking about the same individual, Mr. Chairman. We are not talking about an individual who's been convicted of a crime and has had their gun rights restricted for that purpose. We're talking about an individual who was committed to a hospital for mental health reasons, no conviction of crime. If they've been involuntarily committed, they then have to go back before the court to show the court that they are not a danger to the public or to themselves before they can either purchase or possess a firearm. However, what is happening in Williamsburg with Eastern State Hospital and the Pavilion, individuals are being involuntarily committed because of some mental health issue, no conviction of crime, but just a mental health commitment. They then would arguably lose their gun rights. But instead, they make an appeal of that involuntary commitment. 14 days later, we are set to have our commitment appeal where the Commonwealth is presenting evidence that this individual should in fact be committed to the hospital. They then ask for a continuance. And so the 14 days becomes 21 days. Then they ask for a jury trial. And so 21 becomes 30 or 40 days. And in that time, they are medicated and stabilized. So they're released from the hospital. So when they come before the judge is not asking, should you have been committed a month ago? They're asking, as you stand before me, should you be committed today? And if the answer is no, then their firearm rights are immediately restored without that hearing on whether or not you shouldn't be hospitalized, but that doesn't mean that you should be able to have gun right away either. Okay. And this bill fixed that problem.
Okay. Is there any other question? Is there,
Mr. Chairman?
Senator Obenchain?
So the way that this bill is drafted, can the person ask the judge on that day?
Yes.
To restore their gun rights?
Yes. They can petition the court that day. Upon release from hospitalization, they can petition the court, but there is an actual hearing with evidence to say, this is why I am no longer a danger if I possess a gun. And same day that can happen.
My understanding and recollection of that process is that when they were first involuntarily committed, there was actually a due process hearing pursuant to which they were involuntarily committed because there was an affirmative determination that they were a danger to themselves or to somebody else.
Mr. Chairman, that is accurate.
Okay.
Okay.
So this doesn't, Mr. Chairman, doesn't deprive any individual of the right to seek restoration of their gun rights. And as a matter of fact, they can seek the restoration of those rights immediately. I mean, basically at the same time that essentially the previous commitment order would have been vacated and deemed void.
Mr. Chairman, the only restriction would be if they're hospitalized. If they continue to be hospitalized, they can't file the petition. But immediately upon release from the hospital, they can file that petition to get the gun rights back.
Okay.
Mr. Chairman.
Yes, Senator Obenchain.
So they would be, you're saying that they couldn't file
if they were hospitalized at the time of the hearing, the trial?
No, they can't. If at the time they are filing their petition, they're in a hospital, they have to wait. If they were hospitalized on Monday and get out on Wednesday, they can file on Wednesday. They just couldn't file on Tuesday.
Okay.
Okay. Any other questions? Is there a motion?
Thank you.
Yes.
Thank you.
Moved.
Thank you, sir.
Senator Norman moves to report. Is there a second? All in favor of the motion to remove to report, vote aye. All opposed, no. Ayes 13-0, the bill is reported.
Thank you, Mr. Chairman. Senate Bill 683 adds one line that speaks to outpatient treatment may occur in a local correctional facility or location determined by the appropriate community service boards or behavioral health authority. We continue in our area, as Mr. Green mentioned, having Eastern State, we continue in our area to have people, judges assign, if you're getting treatment, you have to be at a state-run facility. And unfortunately, we are swamped and overwhelmed. We don't like the fact that we're doing treatment in jails, but we are. And so we're toggling people between jail, hospital, back to hospital, and it's really doing them a disservice and interrupting their treatment. This just makes it super clear that if the CSB is involved with the locality, you can receive treatment in a myriad of places.
Mr. Chairman.
Yes, Senator Overton.
I'm curious, DOC and the sheriffs support this?
Anybody from the Department of Corrections and the sheriff's offices? Okay.
And I guess if it's jails, it doesn't even implicate DOC.
It's local, yes, sir.
So, Mr. Chairman, just want to make sure, I mean, does this have a mechanism for, that would force treatment in an outpatient facility in the event that the sheriff deems it impractical or deems that there's a security risk that can't be addressed?
Mr. Chairman, Senator Obenchain, I don't think it would impact current situation. It's just spelling out that, you know, and they continue to tell me that judges are saying, boy, you need treatment, we need to send you to Eastern State. And this is trying to specifically state that treatment is provided in a lot of the places.
And Mr. Chairman.
Yes, Senator Overton.
And I have no problem with that, but my concern would be whether the security concerns and the concerns of sheriffs and jails is being taken into consideration in this bill.
Okay, Senator Boysko.
Thank you, Mr. Chairman. Just for clarification, Senator Hanger and I have legislation that compels a healthcare provider to report to the jails when one of their patients is incarcerated if they are under treatment. So this would marry well, I believe, to the continuum of care.
Okay. Is there any further discussion? Is there a motion? Been moved and seconded to report the bill. All in favor of the motion to report Senate Bill 683, vote aye. All opposed, no.
Ayes 14-0.
Ayes 14-0, the bill is reported.
Thank you, Mr. Chairman, members of the committee. And this next one, let me lay out what I'm trying to do and see if the committee wants to do it. Because if so, I'm sorry, 1072, my bad.
1072.
Yes, sir. Okay, so you may be familiar with the three-part story in the Richmond Times-Dispatch that a local hospital is trying to get patients out of the hospital. So a lawyer appears in front of the court and says, hey, we need to get these guys out of the hospital. They say, okay, they need to be a guardian. They then appoint that lawyer to be the guardian of the people that they're trying to get out of the hospital. Okay? So I understand there's a shortage of guardians. I understand, but it just, you are all learned counsel. But to the layman in the family, that's a hard thing to sell. And so what I'm trying to get at is saying that if you come to the court on behalf of the hospital, you cannot then become the guardian to the person you're trying to get out of the hospital. In these cases, it's reported. I read the story like everyone else. It is reported that he is a limited guardian, so can only do so much. But then in a handful of cases, he removed himself as a guardian of the patient unless that patient comes back to the hospital that he initially brought suit, then he is appointed a guardian back to that person again. I am not making that up. So that's what I'm trying to get at here. A number of people, the stories you've read recently on the other side of the building, that's not what I'm working with. I'm not talking about guardianship after. I'm talking about from the get-go, you ought not to be able to do that.
Mr. Chair.
That's Johnny
Senator,
Layman's view.
What's the problem with, explain what the problem is? I think right
Mr. Chairman,
now,
that
if
means I
you're-
didn't do a
if-
very good job.
If you're an attorney, you don't need a guardian in many cases. I've
No,
seen
sir,
that.
I represent the hospital and bring 5 patients that have been there way too long. I can't do any more for them. I need to get them out. So I come to the court and say, I really need to get Mason out of the hospital. Well, Mason needs a guardian. Mason can't take care of himself. So you know what? I appoint you, your counselor, to be the guardian of Mason. Having brought Mason to the court on behalf of the hospital, you become Mason's guardian when you walk out the door. Again, I'm not casting any aspersions on the ethics of the bar.
Did somebody bring this to your
I don't get
attention?
it.
Senator Mason, did
A
somebody?
3-part newspaper story in the Richmond Times-Dispatch, sir.
Okay, Senator Morrissey?
Thank you. First of all, Senator Mason is absolutely correct. It's one of the most horrific situations that I've ever seen. There was a 10,000-word, 3-page expose in the Richmond Times-Dispatch, and that did just the following. There are indigent people, and I think Senator Mason left that point out, that are in the hospital, and the hospital wants them out. So what does the hospital do? The person who represents the hospital goes into court and says, appoint me the guardian of this individual.
Conflict of interest.
The person is then appointed the guardian, and he then, because he has guardian rights over there, doesn't even listen to the family, removes him from the hospital. And in this situation, one lawyer who was representing the hospital did several hundred cases like that. It was shocking in all of its aspects. And the only reason I didn't bring legislation, Senator Mason, is that I thought it was going to take more time, but I'm delighted to see this bill. But what he just described is exactly what took place.
Okay, so it's not the individual's attorney who becomes the guardian, it's the hospital's attorney trying to kick the person out, who then becomes the guardian. That's a conflict of interest.
Mr. Chairman.
Clear-cut case of a conflict of interest. Yes, Senator Sherrill.
Thank you, Mr. Chairman. So, I mean, I appreciate that situation's horrific, but I've seen guardians ad litem / attorneys used in a million other situations where it's not inappropriate. And so, I mean, a lot of times you avoid the need to appoint a guardian by appointing a lawyer, and it saves everybody money, and it's a situation where there is no conflict. And so, but by doing this, you're going to run up the cost in a lot of other cases where people aren't in a hospital. I mean, I understand the hospital situation, but it seems to me that your bill ought to be directed at a hospital situation and not all guardians ad litem across all situations on the planet, which is what the bill does.
Senator Norman?
It's fair.
Mr. Chairman, I support what Senator Mason is trying to do. In the practice law, there is a very fundamental caveat, and that is to avoid even the appearance of impropriety. And at a minimum, that is a threshold in this situation.
Right. Is there anybody would like to speak for or against the bill? Anybody from the Bar Association or State Bar, anybody that has looked into this?
Mr. Chairman, members of the committee, Alyssa Padden with the Office of the Executive Secretary. Just to be clear, there's no position on the policy of this bill, but I had raised a couple of technical concerns with the patron's office. The first being that the court doesn't necessarily have the information to know whether an attorney seeking to be appointed as guardian has a conflict. So what we had suggested was perhaps the bill could require the attorney seeking to be appointed to disclose any such contacts to the court. The other concern, a committee of judges who reviewed the bill were concerned, particularly the judges that serve in more rural jurisdictions, that without a good cause exception, that there may be nobody available to serve as guardian if you're restricting the appointment in cases where, and it's not just, the attorney for the petitioner, it's an attorney who has represented the petitioner on any matter ever. And so this could, extend to a family member who's a petitioner and the attorney has represented them on a slip and fall in the past. And so there was concern
Would you like
about.
to take this by for the day and work on a amendment? Yes, Senator Peterson.
I was just going to make the point that you could have a situation where the attorney for the petitioner may represent the family. They may be the person with the best knowledge of the situation. And again, if there's not an objection, they may be the best person to be the guardian. Now, I understand there's a potential conflict of interest, and that's why the court would need to sign off on that. But lots of times, you've got a family lawyer or family counsel that may be the best person to serve in that position, but they also happen to be the counsel for the petitioner.
Can we pass this by for the day?
And Mr. Chairman, that's where I started, and I didn't mean to neglect OES. And there also was another suggestion. I just wanted to take the temperature of the committee to see, is this something that we should work on? I try to get Mr. Benjamin's help, or,
Okay, without objection, we'll go by for the day and suggest that the patron talk with the Office of Executive Secretary of the Supreme Court and try to come up with some amendments.
And y'all heard computer trespass already, but John Bell stole my bill. Okay. All right, thank y'all. Thank Mr. Chairman, members of the committee.
Thank you. Senator Morsi, you had a bill you wanted to 813 to take by for the year, I believe, real quickly.
Yes, sir. If I can have 30 seconds to explain, and then I'm going to make a motion. This was the bill that would have created an Amber-type alert in a high-speed chase, and the situation involved a young child who was killed because of a crash. And if the committee chairman could recognize just her mother, just to stand, Miss Chandrika Williams is in here. If she can just stand from that. Just acknowledge her. She is the mother of the young lady who has traveled today to present it. But after introducing this bill, I had 2 meetings with the state police, specifically to discuss whether or not the Criminal Justice Information Services Unit of the Virginia State Police could address this matter. And they've agreed to look at it over the next year. And I've drafted a letter for you, Mr. Chairman, to send to them to ask that they report back within the year, both to you and to me. So with that stated, I'd ask that the bill be passed by for the year.
Okay, second. All in favor of the motion to pass it by for the year with a letter should vote aye. Continue it for the year.
Thank you, Mr. Chair.
Okay, 15-0, the motion carries. Senator Hanger, you've been sitting there very patiently.
Thank you, Mr. Chairman, members of the committee. I have 2 bills in front of the committee this morning, Mr. Chairman. Senate Bill 602 and 603. I think we could begin with 602. Both of these bills are recommendations of the Mental Health Commission that I sit on, and these specifically deal with transportation where there's a temporary detention order. As many of you may be aware, several years ago, we did a pilot program down in the Mount Rogers Community Service Board area where we used private providers rather than the law enforcement to provide transportation of these individuals with TDOs. Worked well, so I think 2 years ago in the budget, we included funding to roll that out statewide. And it's my understanding it's working very well. Both of these bills are efforts or recommendations to tweak the statutes that should be helpful. The first one, Senate Bill 602, establishes procedures for changing the transportation provider designated to provide transportation to a minor or other person who's the subject of a temporary detention order. It allows the magistrate to make that change prior to the transportation being transferred or beginning in process. So that's all this one does. It's in 2 sections of the code, one dealing specifically with minors, the other dealing with individuals of age.
Any questions of the patron? Is there anybody in favor of the bill? Anybody against the bill? It's been moved and seconded to report the bill. All in favor, vote aye. All opposed, no.
Ayes 14, no zero.
Ayes 14, no zero. The motion carries.
Thank you, Mr. Chairman. Senate Bill 603, I believe the underlying policies here have been sorted out and are in agreement, I believe, broadly, but it did require a couple technical amendments that I think Charles has.
That's correct, Mr. Chairman. There are 5 amendments. I have copies to pass out, but basically the amendments are all technical in nature.
Okay. Is there a motion to adopt the technical amendments? Second, all in favor, say aye. All, motion carries. Is there a motion, is there anybody in favor or against the bill?
Okay, Mr. Chairman, look, one further amendment, Charles, I don't think this one got to you, that was brought to me this morning. I view it as a clarifying. The first 2 dealt with, one was a technical one, one provided parental notification to the parents involved with the minor. This one was brought to me by the Sheriff's Association that went on line 52, just a clarifying amendment to say primary law enforcement rather than just law enforcement on line 52 after minor.
I do not have that amendment on line 52, but that amendment can be made.
You view that as technical, I think?
Yes, Mr. Chair.
I would ask for that amendment.
Add the word primary.
Primary law enforcement rather than just law enforcement.
Line 52.
Line 52 after minor, insert
After minor.
primary.
Okay. Second, is there a second to that motion? All in favor of the motion, say aye. Aye. All opposed, no. Motion carries. Is there anything else?
That's all I have, Mr.
Is
Chairman.
anybody in favor, anybody against? Is there a motion to report? Okay. Who wants to speak for it? Okay, Becky?
Mr. Chairman, members of the committee, Becky Bowers, I'm here with the Virginia Association of Community Services Boards. I haven't seen those technical amendments. I just want to make sure. I was told that it was good as it was. And so reserving the fact that we may have some issues, we'll get back later on. We worked with Senator Hanger on this, and we support the bill in general.
All right. So you want to, this is not a gun bill, it's,
This is actually, that's the previous bill, which I just thought of.
we've already done that.
Okay.
We'll take this, do them in order, okay?
Okay.
All right, is there a motion to report the bill as amended?
I'll move it.
Is there a second? All in favor of the motion to report the bill as amended, vote aye.
Ayes 15, no zero.
Ayes 15, no zero. The motion passes. The bill is reported as amended.
Thank you, Mr. Chairman.
All right, okay. All right, now I understand there's some bills we got to do. Senate Bill, I can't read it. Senate 64, Senator Lucas?
Yes.
Okay. 60.
Do you mind today?
We got to get these in the
Huh?
You're next, Okay. Yeah,
Senator Lucas,
Senate Bill 64.
Good morning, Mr. Chairman. Thank you, and I apologize for my voice, but I've been sitting between Saslow and Barker for about a week,
This is already federal law.
and I think it finally caught me. Mr. Chairman, I have 3 bills. Senate Bill 64 on page 3, Senate Bill 71 on page 4, and Senate Bill 949 on page 12. And if you don't mind, I will start with Senate Bill 64 on page 3.
Okay, paramilitary.
Yes, sir.
All right.
Mr. Chairman, members of the committee, Senate Bill 64 was born out of the violence we saw in Charlottesville in 2017, and a significant rise in hate violence and a threat posed by trained and organized militia that are growing all over the Commonwealth and the country. On the streets of one of Virginia's cities, we saw organized, trained extremists armed, powerful weapons marching through our streets. Interviews with the leaders of these groups reveal that they were operating as unregulated, uncontrolled, unaccountable, self-appointed so-called security forces. Their appearances and their power, and the power of their weapons, greatly increased the likelihood of greater violence, confusion, and even large-scale confrontation with legitimate law enforcement authorities. Current law only prohibits teaching and training with one or more persons to demonstrate how to use, apply, or make a firearm, explosive, or incendiary device, or a technical capable of causing injury or death if the purpose is to use these skills in furtherance of civil violence or disobedience. Senate Bill 64 enhances the current prohibited paramilitary activity statute by providing that a person is guilty of unlawful paramilitary activity if they assemble with another person or persons with the intent of intimidating one person or a group of persons with any firearm, explosives, or incendiary devices. I have further information, Mr. Chairman, members of the committee, but I choose at this point to call up some of the experts, if you don't mind, please.
Is there a substitute to this bill? No? Okay. There is? Okay, the motion is made to adopt the substitute. All in favor say aye. Aye. All opposed, no. Anybody want to explain the difference?
Thank you, Charles.
Mr. Chair, the substitute basically changes the language to basically read what Senator Lucas just explained, which is it makes the crime to assemble with one or more persons with the intent of intimidating any person or group of persons with any firearm, explosive, or incendiary device or any components thereof.
Okay, is there a second to the motion to adopt the substitute? All in favor of the motion say aye. Aye. All opposed, no. Substitute's adopted. Okay.
Thank you.
Next.
Good morning, Senator Edwards,
Yeah,
members of the
start with
committee.
the town. Okay.
Scott Miles here on behalf of Attorney General Herring. We've researched the issue and we're confident that the law as amended would be constitutional and that it would withstand scrutiny on appeal if challenged.
Okay, thank you very much. Next.
Hello again, Jonathan Romans, Richmond, Virginia. Just wanted to mention my first public gun violence prevention event that I attended here in Richmond was December 14th, 2013 in a public park. When I arrived at the park, there was an assembly of people gathered in prayer led by a clergyman. Surrounding these people in a large circle was a group of armed gunmen, all wearing the cap of one single organization, the VCDL Incorporated. When I went past these armed gunmen into the group through the entirety of the prayer vigil, these individuals gathered in prayer were afraid to talk to me because they thought that I was one of these individuals making this circle outside of the group, infiltrating their group. So yes, I do support this bill.
Okay,
thank you.
Next.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. What happened in Charlottesville were a number of people gathered, not only carrying weapons, but wearing uniforms. I'd point to the fact that 44-120 protection of the uniform is it's an offense to wear a uniform which is substantially similar to the uniform of the United States Armed Services, which I believe led to a lot of confusion as to whether these people were legitimately there to provide protection and they had a right to be there or not.
Okay, thank you. Laurie?
Good morning, Lori Haas with the Coalition to Stop Gun Violence, and for the reasons stated, we support the bill. Thank you.
Thank you. Anybody against the bill?
Mr. Chair, can I ask a question?
Yeah, Senator.
Mr. Chair?
Yeah, Senator Peterson.
And I don't know if it's a question for the AG, but before the opponents speak, this is come forward. This is a Class 5 felony. What are the time limits for a Class 5 felony?
Maximum penalty is 10 years of imprisonment.
Maximum is 10 years.
That's correct.
Okay, further question.
Is that what it says?
It's a Class 5 felony.
Yeah.
So,
Okay, go ahead.
in other words, if people assemble and they have firearms and it's a judge that they're intimidating other people, and clearly people have objectively felt to be intimidated, are we going to indict these people? Are we going to, I mean, what's the standard between what is a First Amendment exercise and what is quote-unquote intimidation? Because I don't know if we have enough beds in our prison system for some of these situations.
Well, I think the difference is it's not that people feel subjectively that
I said
that they
objectively, sir. I didn't say subjectively. I said objectively.
It's not the feeling of the person who feels intimidated. It's whether the people assembling have the intent to intimidate.
Further question.
Well, it further goes further. It's intent to intimidate with any firearm or explosive or incendiary device.
So
Yes.
we've had demonstrations within Capitol Square in the past 2 weeks. Would it be your position that those would implicate this law and therefore be Class 5 felonies?
It would be the prosecutor's burden to show.
I know about the burden. I'm saying, is it your position? Don't tell me about the burden. Tell me, is it your position that that would include this law?
Well, I'm not an elected Commonwealth's attorney. I'm not in the position
Well,
of
you're speaking
deciding
on
whether
behalf
to
of an
charge.
elected official.
I am. We believe the law would be constitutional.
No, I didn't say that. I said, would it apply to the situation we had 2 weeks ago?
That's up to the elected Commonwealth's attorney to make that decision.
So you think it could?
That Commonwealth's attorney could decide to bring the charge, would then have the burden of proving in a court
I
of
know what the
law
burden is,
to
thank
the
you.
satisfaction of a jury or a judge, beyond a reasonable doubt, that the defendants had the intent to intimidate.
Okay. All right, any other? Go ahead.
Yeah, so the answer is yes.
Those against the bill, you got 3 minutes.
Yeah, Philip Van Cleve, VCDL. Senator Peterson was sort of hitting on our concern about this. Number one, it's a felony. I mean, it's a big deal. Number two, intimidation. You get into subjective areas as far as I'm concerned that deal with felonies. So we strongly oppose this.
Isn't this kind of like yelling fire in a crowded theater? If you're intimidating somebody with a firearm, that's not hard to prove.
Some people are pre-intimidated. I mean, you know.
You got to prove that. Okay, go ahead.
Good morning, ladies and gentlemen. My name is Richard Pyle. I'm a citizen of Dinwiddie County. Since 1607, Virginia has had a strong tradition of service to the community through the form of militias. Unless Article 1, Section 13 of the Virginia Constitution is changed, an unorganized militia is still a legal entity in this Commonwealth. You use the words to intent to intimidate. Such subjective language associated with a Class 5 felony is, in my opinion, reckless and provides a situation where a simple parade, a legal parade, if they are carrying firearms, someone who is easily intimidated could prove the case that that was their intent. These are legal entities within the Commonwealth of Virginia. Currently, could be called up under the orders of the governor for the Commonwealth defense or the defense of the nation. And until that's changed, this is not a law you want to go down. This is not a road you want to go down. And thank you, Senator Peterson, for your comments.
Okay. Next, Rich Creek, Dallas County.
I find this quite amazing that the veterans.
Say your name again, I'm sorry.
My name is Joe McClung from Rich Creek, Virginia. I find it quite amazing that the veterans of foreign wars can't have a cemetery for veterans who passed away, can't have a salute or practice or drill or anything like that. And also, it also goes after training of firearms and everything at a thing. And also, I shoot combat matches, and sometimes you got to dress in military material in order to shoot at these pistol matches and everything else. So it's not necessarily a pre-military. It just might be you gotta dress up to fit the occasion to shoot. So this is a joke.
Okay, thank you.
Sorry.
I'd like to remind the committee that peaceable assembly is protected by the First Amendment, and I would once again defy anybody to prove that what we saw on 20th January was anything but peaceful, no injuries. This is no different from the regime of George III that provoked the Commonwealth into revolution 245 years ago. It also is highly subjective. Who decides? Who decides what the uniform is? Who decides what the cause is? Who decides which ones are acceptable, which ones are not?
Have you looked at the substitute? It's not the original bill. Okay. Okay.
All right. Everybody's intimidated by different things. Everybody's offended by different things. It's not practical or possible to make a law and make a society that will never offend anybody.
You got 25 more minutes, or seconds.
Don't you would.
Thank you. Frank Chambers from Danville, Virginia. The Commonwealth, the United States Commonwealth of Virginia, both speak for themselves. Well-regulated militia is part of the citizenship.
Okay.
And any infringement on that, and to sit here and say, as spoke like here on I was here on the 20th. We marched with Black Lives Matter, we marched with Black Panthers, we marched with gay and trans activists, all for the same thing.
Okay.
And even members of this Senate has referred to us as extremists, white supremacists, which is the first from the truth. So any bills you're presenting here.
Time has expired. So if you all would just state your name real quickly and say you're against it.
Morning, Lou Simpson, Fredericksburg, Virginia.
Okay.
I stand opposed to this legislation.
Okay.
Patricia Webb, Hanover, Virginia. What this legislation would do is effectively squash First Amendment rights. You could say that the rally that we saw, the peaceful rally that we saw on the 20th, intimidated a lot of people. Was it intentional to intimidate?
Okay.
Who decides
All right.
that?
Thank you. All right, next, just state your name real quick.
Terry A. Santori, living between Norfolk and Virginia Beach.
Okay.
And
You're against the bill. You're against the bill. You're against the bill.
Against the bill,
Okay,
yes.
Thank you. All right, just quickly state your name.
Will Shaw, Louisa County. I'm afraid the bill won't be enforced fairly across the
Okay.
Commonwealth.
Okay, thank you. Next.
John Quapis, Chesterfield. This bill really opens a door to abuse and violation of the Second Amendment. The Charlottesville thing did not arise out of the guns. It arose out of Antifa, people carrying clubs, throwing rocks, carrying baseball bats. This doesn't
Okay.
cover those
All right,
people.
Thank you. Is there a motion?
Mr. Chairman.
Any motion?
Mr.
Yes,
Chairman.
Senator Stewart.
Thank you, Mr. Chairman. And with all due respect to the gentle lady who's one of my favorite legislators in the whole General Assembly.
Except for this moment.
This statute, this statute is probably worse than the brandishing statute. And I've seen people in court convicted on their own private property where they had a gun and they had it maybe holding it right here or holding it somewhere like that. And somebody said they were intimidated by that gun. And the judge convicted them of brandishing.
Mr. Chairman, they needed a
Just
better
give me a
lawyer.
second. Just give me a second. I didn't say I represented them. I said I saw them convicted. And here's the situation. If I'm standing, I think this would have criminalized the rally on January 20th. There's no question about it. I was in the Marine Corps, and I had an M16A2, and I was very proficient with it. And I'm not going to stand out on Broad Street with it because I don't need to. But if I wanted to, and I stood there parade rest with that weapon, anybody who went into a judge and testified that they were intimidated by me holding that M16A2 is going to be believed by a judge, and I'm going to be convicted. And that's what a statute like this does. It is a very, very, very severe restriction on our First Amendment right. You don't even have to get to the Second Amendment of the Constitution. It's a First Amendment infringement. I disagree with the gentleman from the Attorney General's office.
Steve.
It is so subjective that it just goes way too far. And I
Counsel
think it will-
Steve.
Mr. Chairman,
Benjamin.
Senator Stewart makes persuasive points. And what I thought of, if the patron wished, was an opportunity, a means to tighten this. Under current law, it is a crime for a person to point, hold, or brandish a firearm in such a manner as to reasonably induce fear in the mind of another. And so one solution would be to add a subsection to the brandishing statute that would say if a person violates subsection A, that is, points, holds, or brandishes a firearm in a way that reasonably induces fear, while assembled with one or more persons with the intent of intimidating any person or group of persons, he shall be guilty of a Class 5 felony. And so what it would do, this potential solution, would take conduct that is currently unlawful and then add in, if you do this, if you violate current law while assembled for the purpose of intimidating, and then it's a Class 5 felony. So that is one potential solution if the patron wishes.
Senator Morsi.
Senator Lucas, I was working on similar language as to Mr. Benjamin and would ask if you would consider it a friendly amendment on line 19, where you keep that language assembles with one or more persons with the intent of intimidating any person or group of persons with any firearm, any explosive or incendiary device, or any components in combination of thereof, and then add the following language. And commits any overt act such as to reasonably induce fear in another. In other words, we just add the language of an overt act onto your point Item 3 on line 19.
Mr. Chairman,
You can't count, first of all, council.
Mr. Chairman, I think we might refine that by removing overt act and substituting point, hold, brandish.
That's
Okay.
same thing, yes,
So
Mr.
either
Chairman.
approach, you can do it within this paramilitary section, or you can amend the brandishing statute.
I'd like to do it within this paramilitary activities section, if you don't mind. Mr. Chairman,
Okay, yes.
I've been here long
Senator-
enough to get a sense of the vibes of this community, this committee. So I think a half loaf is better than none at all. So I will accept the friendly amendment coming from Mr. Benjamin.
Is the amendment is articulated by both council and Senator Morsi, and agreed to by the speaker, by the patron?
Mr. Chairman.
Is there a motion to adopt that? Yeah.
Can we have that
Before we
reported?
adopt that amendment, I'm just curious, to Senator Morsi and Mr. Benjamin, don't you all think this is better placed within the brandishing statute because there's a body of law surrounding the brandishing statute?
Mr.
And
Chairman,
Senator Stewart, I do. I do think it fits better within the brandishing section, but I don't mean any harm to the bill.
Mr. Chair?
Senator Peterson.
I think the senator's point was to add to this paramilitary section based on activities we've had in this state.
That's correct.
And I appreciate, and I think she's correct. I think what Senator Morrissey's saying is we need to distinguish an act versus a First Amendment speech. And I think the best way probably to do that is to add the language, but also reference the statute on brandishing. So you could actually reference the code section 18.2 whatever it is.
Mr. Chairman, that could be done. So on line
And I support
19,
that.
what we might say is violates 18.2-282, subsection A, while assembled with one or more persons.
And I would support that amendment.
Is that, all right, is there any further discussion? All in favor of that motion as articulated, vote aye, say aye.
Aye.
All opposed, no. Motion carries. Okay, the bill's before us.
Move it be reported.
It's been moved and seconded to report the bill as amended.
Mr. Chairman.
Does it have to go to finance?
One question
It's got to be re-referred to finance.
But before you do that, Mr. Chairman, could you have Mr. Benjamin clarify for me where this will be found in the code?
Where you want it.
Okay, thank you.
Right here, same place.
Right here.
Okay, all right. All in favor of the motion to report and re-refer to finance, the substitute, vote aye. All opposed, no.
Ayes 9, no 6.
9-6, the motion carries. Thank you, Senator.
Thank you, Mr. Chairman, members of the committee. Senate Bill 71. Hopefully, this will go down a little bit easier. It's a bill that expressly clarifies any person to possess a firearm on school property other than persons expressly authorized by statute. Currently, Virginia law already bars special conservators of the peace from bringing guns into schools, but last year, at least one school system was attempting to find a workaround that would have allowed more guns into school. This makes it clear that only trained, qualified law enforcement personnel will have guns for security purposes. The law already provides several options for employing armed security personnel with full law enforcement training, but the law doesn't allow for the arming of unqualified personnel, and for good reason.
Okay, is there a motion to report the bill? Is there any discussion?
Yeah.
Okay, Senator Ovenchain.
Are you calling for discussion?
Yeah.
Well-
Questions, any questions?
Well, first of all, would you consider somebody going through the process of becoming a conservator of the peace pursuant to the Department of Criminal Justice Services standards to be adequate training to give the comfort that they are qualified to possess firearms in a school?
Mr. Chairman, I would respond by saying that this is to prohibit firearms by any person who is not trained and who is not law enforcement in child daycare centers or public or private preschool institutions.
Okay.
but somebody who's been trained and certified as a conservator of the peace pursuant to the Department of Criminal Justice Services standards would be okay?
That's what the bill says.
Okay, thank you.
All right, anybody speak in favor of the bill? Anybody against the bill? You in favor of the bill? Okay, just state your name.
Jonathan Romans, Richmond, Virginia.
Okay.
I am an independent gun violence prevention researcher as
Okay.
well. From my analysis in Virginia, since the beginning of 2013, of the 65 incidents that happened in which 4 or more people were either wounded, shot, and/or killed, only 3 have taken place in what could be defined as a gun-free zone. In other words,
Okay.
the correlation between gun-free zones and mass shootings is a complete myth.
All right,
Thank you.
Thank you very much. All right, just state your name. If you're in favor of the bill, very briefly.
Bonnie Atwood. I represent the Fire Prevention Association. We are in favor of the bill. I think fire marshals would be allowed to carry their weapons.
Okay, all right.
That would be the condition by which we would
We got
favor
a lot
it.
of bills here. We got to move this thing along really quickly.
Yes, sir. Lori House with the Coalition to Stop Gun Violence. We support the bill.
Okay, thank you. And you all against the bill, I guess? Just,
Yes.
okay, stand up, just, okay, thank you very much. Same group. All right, thank you very much. Is there a
Mr.
motion?
Chairman,
Yes,
Mr.
Senator
Chairman,
Simpson,
that's-
who's this? Norman, Simpson Norman.
Actually, McDougal. Mr.
McDougal,
Chairman,
oh,
but
sorry, McDougal.
you have to give the public the opportunity to express their views,
All
even
right,
if you
come
don't
on
like
up,
them.
Come on up, go ahead, state your name and we have a very serious time shortage here. Go ahead.
Yes, sir. My name's Timothy Ham, Arlington, Virginia. There are a lot of folks who can't afford to live in nice communities like Arlington that are bubbled off from the rest of the world out there. Here in Richmond, there are some sides of town that have problems with gun violence, and to protect themselves and their families, they do need to carry a firearm. There's a legal avenue by which they do that, and I and a number of folks here would take exception to the fact that we're not trained to handle a firearm safely. I have a concealed carry permit in my wallet right here. I shot 3rd Award rifle expert and pistol expert in the Marines to get it. So I take exception with this notion I'm unqualified.
All right, okay, yeah.
Philip Van Cleve, VCDL. Well, this sweeps in child day centers and religious preschools into school property. So now parents that can currently simply go to the school, pick up their children, now have to go through the same rigmarole they have to go through for K through 12. We're just continuing to expand that. And there really isn't a problem here that we're addressing, other than gun-free zones are not the ideal place for safety.
Okay.
So we oppose this because it's expanding it.
Okay, just state your name, you got a minute and a half.
The Supreme Court ruled on February 22nd, 1989, that the government is not liable for protection of the people from violence of each other, even though they know it, only if they are under custody of the state that the government is liable. So therefore, by having no gun-free school zone, if something happens, that means the parents of everybody has a right to sue the government.
Okay.
Thank you.
All right, thank you. You got 50.
Good morning, ladies and gentlemen. Richard Pyle, citizen, Dinwiddie County. What this law does is actually make it more dangerous for some single mothers with, say, stalkers or abusive ex-husbands to put themselves at risk. They have now a provision in the code that would allow you to transport to a school zone as long as that firearm is locked in the vehicle when they go into the building. This could possibly change that code so that now that is no longer a possibility. So the single mother has 2 choices. Either go to the school without her firearm and the stalker, abusive spouse knows that, or go there with it in defiance of the law, and now that person knows that and could call and make problems for them. Thank you.
Okay, thank you. All right, very quickly. 5 seconds.
What this bill is doing is actually creating a more dangerous situation. I'm sorry, Patricia Webb, Hanover County. You're creating a situation where somebody needlessly has to handle a loaded firearm in order to go into a daycare center or preschool and pick up their child. They would have to disarm, go pick up the child, come back and rearm themselves. You're also creating yet another gun-free zone, and contrary to what the comment was made earlier, we have seen undisputable evidence that gun-free zones are frequently targets for mass murderers
Okay.
because they are defenseless
Time's
places.
expired. Just state your name, please. Time has expired.
John Quapis, Chesterfield. First of all, this should not apply to private entities. Let the private entities, schools, religious schools, et cetera, decide this themselves. This leaves these people, as the lady said, open to being attacked. Okay. Criminals don't respect the law of a no-free gun zone sign. At the minimum, people holding CHPs should be allowed to have access without being denied. Thank you.
Thank you. All right.
Mr.
Is there a
Chairman,
motion?
Mr.
Yeah,
Chairman.
Senator Serval.
It's a quick question.
We got
I'm sorry.
1 minute past the expiration.
I understand. I just wanted to say that, first of all, I support the intent of the bill, but I would just note for the patron that one of the concerns that I have that I hope might be worked out as this moves through the process is that many child care centers or preschools are located in churches. And I know with some of the attacks that have been going on in this country, especially on synagogues, that some religious facilities feel the need to have armed guards to protect themselves. And I have a little bit of concern that this might prevent that in some way. And so I would hope that as this moves through the process, there might be, I just haven't had a chance to figure out what existing law is, but I want to make sure that if somebody wants to have armed guards at their church, that they can still do that under this bill. So,
thank you.
I would hope
Is there a
consider
motion?
that.
Mr. Chairman.
Yeah,
Mr. Chairman,
Senator, McDougal.
helpful to be able to talk about the bills, but if I'm reading this, I think, and I don't know that this is the patron's intent, but this says, number one, you can't possess the weapons on the property of a child daycare center, public or private, or religious preschool. So, Mr. Chairman, the way I think this is written, regardless of when you are on the property of that religious preschool, you couldn't carry the weapon. So if it was a Sunday or a Saturday for church or synagogue that you were there, even when the religious preschool is not operational, you would still be in violation.
Okay, is there a motion? We got to move this along.
I move be reported.
Is there a second? It's been moved and seconded to report the substitute. Report the bill. All in favor say aye. Vote aye. All opposed vote no.
Ayes 9-6.
9-6. Okay, Senator Sasslaw, Senate Bill 14.
Mr. Chairman.
Yeah, Senator Lucas, do you have another one?
Yes,
I don't think
on
it has to
page
it had-
12.
Huh? You got it. All right, 949. Sorry, Senator Sasslaw, 949. I'm sorry, I thought you had those.
Yes, sir. Mr. Chairman, members of committee.
949.
Senate Bill 949 is a compilation of several policy options approved by the Joint Commission on Healthcare based on staff study of forensic nursing in Virginia. The intent of the bill is to improve how victims of sexual assault and abuse receive care and treatment in Virginia by, one, expanding the type of participants invited to meetings developed to improve care for victims, and two, decreasing the likelihood of that victims having to pay for their own care after being assaulted, and three, addressing issues with billing and reimbursement for forensic nursing services. And of course, we have our director who will respond to any questions you have,
This recommendation, Joint Commission on Healthcare?
on which you set, Mr. Chairman.
Yes, go ahead.
We do have some technical amendments. You've got them? Fabulous.
All right. Technical amendments.
Yeah, Mr. Chair, I believe the technical amendments have been incorporated into the substitute before the committee right now.
That's wonderful.
Okay, good. All right, any questions?
Thank you.
Any opposition? Is there a motion to report the substitute and refer to finance? I'm sorry, we have to adopt the substitute. All in favor of adopting the substitute, say aye. Aye. All opposed, no. Motion carries. Is there a motion to report and refer to finance the substitute? Motion has been made and seconded. All in favor of the motion, vote aye. To report and re-refer the substitute to finance. All.
Ayes 14-0.
14-0, the motion carries. The bill is reported and re-referred. Senator Saslaw. I lost that ticket.
Mr. Chairman and members of the committee, I have Senate Bill 14. Last December 26th, the Alcohol, Tobacco, and Firearms Division, the Treasury Department proposed a regulation that bans sale or possession of what we refer to loosely as bump stock, but trigger activators. And it's defined, I move that we adopt the substitute.
It's been moved and seconded to adopt the substitute. All in favor say aye. All opposed, no. Motion carries.
And it went into effect on March 26th, and you had till June 26th of last year to either hand in, if you had one of these trigger activators or bump stocks, or destroy it. And after June 26th, anyone in possession of this faced up to 10 years in prison and a $10,000 fine. That's currently the federal law, okay? It went to twice on March 26th and March 28th, the U.S. Supreme Court. They allowed it to go into effect. 2 U.S. Circuit Courts of Appeals have upheld it. It is the law. And what the substitute does is it essentially restates it restates the federal regulation. So what we're doing is we're taking the federal regulation and putting it into the state code.
Any questions of the patron?
Mr. Chairman.
Senator Serval.
Thank you, Mr. Chairman. Again, I support the intent of the bill. I just had a question. Maybe this might be for council too, but I had in one of my conversations with one of my constituents about these things, he directed me to a YouTube video where somebody took a stick and stuck it in the trigger and then bounced it against themselves and were able to effect the same result. And so, obviously we're not going to ban sticks, but it just strikes me that it ought to be a device that is designed to allow a blah, 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 and or, I don't know whether
well, we can look at that as it goes through the system, Senator Serval, but this duplicates the current federal law.
Okay.
Any further questions? Is there anybody against the bill? Anybody in favor of the bill? All right, we got some.
Do you possess one?
The usual. All right, well, let's do this. Just state your name and say what you're against.
Philip Van Cleve, VCDL. Well, the fact that the courts didn't do a stay on it doesn't mean it's not unconstitutional. So that battle's still being fought.
Okay. All right.
Basically, what this law does is tell the insane person to be more efficient in what they're doing, because when you shoot single shot, you hit more targets.
Okay.
Thank you.
Okay.
Ladies and gentlemen, Richard Pyle, Dinwiddie County. The federal bump stock ban was actually very specific. It did not include binary triggers at all. Binary triggers is a mechanical device that can allow you to fire on the squeeze and fire on the release. That increases the rate of fire, but it was not prevented under federal law. Those are still for sale.
Mr. Chair, there is a provision in the substitute that basically says nothing in this section shall be construed to prohibit a person from possessing anything that's in compliance with the National Firearms Act.
That's not covered under the National Firearms Act.
So therefore, it would not be applicable to this bill.
Okay, so binary triggers under this bill would still be allowed?
Correct. The only thing this tracks is the provision under ATF regulation, which is barred.
I apologize. The gentleman used the word binary trigger, and it's in the word binary triggers in his bill.
Okay.
I apologize.
All right, next. Very quickly, got a minute and a half.
Okay, Patricia Webb, Hanover County. First off, I would say that if this bill, according to this bill, if it's legal under federal law, it would be legal, then why are we passing the bill? Why are we cluttering up our legislative process with another bill that simply restates federal? And I would ask also, The current bump stock ban is still working through the court system. So if that interpretation was overturned, would this bill then not have any effect whatsoever? I have that question for the patron.
It is not before the court system anymore because the Supreme Court refused to hear the appeals from the two, there was two, I think, a Fifth and Sixth Circuit ruled that it was constitutional.
Okay.
If I may ask Mr. Van Cleve, is it not still under appeal?
Okay.
It is still under appeal.
Okay.
There are still cases live.
Thank you. You got half a minute left. Go ahead.
John Pulliam, Fluvanna County. I'm a retired Army. And I'm going to tell you, all these bump stocks and stuff, they're novelties.
They're what?
They're novelties. You wouldn't use that to do anything, except just waste ammo. They do not improve your accuracy. They do not help you out at all. It seems like this is a law to put on the books because there's already a federal law. What are you doing?
Okay. Thank you.
All
right, 1 second left. Just state your name. You're against it.
Timothy Ham, Arlington, Virginia. Oppose the bill. All these came about in the wake of the Virginia Beach shooting, and nobody can explain
I understand.
how this would have affected
expired. Just state your name.
Frank Chambers, Danville, Pennsylvania County. Why are we spending taxpayer money to put laws on top of federal laws?
Okay, thank you. Try not to repeat what's been said because your time's expired.
My name is Lucas Wakefield from Northumberland County, and I'm against this law.
Okay. Same.
Lou Simpson, Fredericksburg, Virginia, and I stand opposed to the bill.
Okay, all in favor of the bill? Just very quickly.
Good morning, Lori House with the Coalition to Stop Gun Violence. We support the bill. It makes sense to get this into the Code of Virginia so that law enforcement, local, state, and can enforce this prohibition. Thank you.
Okay, next bill.
Good morning, Tanya Shar on behalf of Brady. For the same reasons, we support the bill.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. I remind you that we do actually put federal law into state law many, many times so that we can enforce it with our own police force.
Okay, is there a motion?
Mr. Chair?
Yes, Senator, who's that?
Peterson.
Peterson.
I've got my legal counsel over here furiously researching federal law. I think instead of where it says a device that allows a semi-automatic firearm, I think we want to say a device designed to allow a semi-automatic firearm. And looking at the code, I think it's important that, as Senator Servo said, you could take anything. You could use a finger itself, by the way, to be a device that allows, consistent pressure on a trigger. It needs to be something that's designed or manufactured for that purpose.
Okay. Is that amendment?
If it makes them happy, I'm fine
Is
with
that
it.
amendment, council, got it?
I got it, Mr. Chair.
Okay, all in favor of the, it's moved and second to adopt the amendment, all in favor say aye. Aye, all opposed no. Motion carries. Is there a motion on the bill to report and re-refer to finance? Been moved. Is there a second? Senator Lucas seconds the motion to report and re-refer the bill as amended to finance. The substitute is a bill to report and re-refer the substitute to finance. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 9, noes 5.
9-5, the bill is reported and re-referred.
Mr. Chair.
Now, Senator Deeds.
I understand there's one bill left that has to go to finance. It's 436.
Actually, more than that.
Is that right?
Yeah, what is 436? What's it about? Okay, 436. Whose bill is this?
It's Senator Servo's.
All right, 436, Senator Servo. 436.
It's a bill that creates a voluntary do not sell list for firearms. A person can put their own name on a do not sell list.
Okay, we heard that in subcommittee?
No, we took testimony last week from
That's
the
right.
professor
We did.
from Alabama
That's
about
right.
it.
We took testimony last week. Okay, is there a motion to report and re-refer to finance? Did that go to finance?
Second.
Yeah, okay. Is there a motion to report and re-refer the bill to finance?
So moved.
It's been moved and seconded. All in favor of the motion, vote aye. All opposed, vote no. Okay.
Ayes 8, noes 5.
Okay, 8, noes 5.
And
Bill is reported.
Mr. Chair, I understand you're waiting on me before you had a vote on Senate Bill 949, or no,
581.
581.
Senator Howell's bill, Senate 581, Senator Howell said we could vote without her being present. Is there a motion on the bill? Report and re-refer to finance. It's a substitute. Report and re-refer the substitute to finance. Are you ready to vote? All in favor of the motion, vote aye. All opposed, vote no.
I'm almost there.
Almost there.
Thank you.
Ayes 7, noes 8.
Ayes 7, noes 8. The bill is not reported. Okay. Now, we have several other bills. Frankly, it's 11:30. How many more bills do we need to take up before we leave? Can we come back and have another meeting? We're going to have another meeting. It's 11:30. Huh? When can we do it? When can we? Wednesday, the next meeting will be Wednesday afternoon. We'll take up the bills that need to go to finance first. Okay, thank you all for coming, and the meeting is adjourned.
Okay. It does.